Yes.
May I permit to mention one section 11 matter, Lordship. Inclusion in the list, Lordship.
Do we mention item number 1?
Your Lordship, I appear for the petitioner in this matter. Your Lordship, the matter has been settled. This was my Section 11 application. Your Lordship, the terms of settlement is ready, but this has not been stamped, punched, Your Lordship. I was praying if Your Lordship gives me time, I'll file it within the course of the day, Your Lordship.
Do you want the settlement to be part of the order?
Yes, Your Lordship.
Can you come back during the course of the day?
Your Lordship, I can come back at 2 if it
Come back at 2.
comments to you. Your Lordship, my learned friend is in. I'll come back at 2, Your Lordship.
Both of you come back at 2. Settled, right?
I've got respondent number 3 to 6.
Who are the other respondents?
And
Your Lordship,
1 and 2 are settlement is between the petitioners and the respondent 3 to 6. Respondent 1 and 2 is the previous owner of the property, and there's no dispute between them. My order can be passed. We file the settlement
in the course of
during the course of the day.
So you bring the get it
After
stamped.
settlement,
Come at 2 o'clock. I'll take it.
I'll come back at 2.
I'll record the order and then I'll dispose it off.
I'll come.
My lord, item number 2 and 3, one is my friend's section 29A application. The other is my section 14 read with 15 application, my lord. For my lord, changing the arbitrator, although we don't oppose, my lord, extension. If your lordship recalls in this matter, my lord, they had also pleaded that there's a need, my lord, to change the arbitrator. Your lordship, my lord, had directed them to take instructions on, my lord, who could be the alternative arbitrator, because I had, my lord, gone to the extent of saying, let them choose any arbitrator.
Yes.
So, my lord, now, my lord, it appears that, my lord, they have filed an application, my lord, trying to, my lord, justify that those several sentences, almost running into 1.5 pages, was a typographical error.
My lord, I'm praying for a short passover. My senior is on it, like in court number 6. He will be arriving soon. And give a short passover.
Can you do it today?
So, next week, keep it next week. Learned proxy counsel so and so appears and states that the main outgoing counsel is engaged in another court. Let this matter be listed next week.
Your lordship is keeping it next week, my lord.
Next week.
Great.
Number 4.
My lord, I am appearing for the petitioner, my lord. In this matter, Mr. Devnath Ghosh is appearing, my lord. Kindly pass it over, my lord.
First 5 matters, no passover. Proxy counsel so and so appears and states that counsel is busy in another court. Keep it next week. Number 5.
Lordship, I am for the respondent, your Lordship, in this matter.
And for you're there? You're there in this?
Item 4.
Item 5. None for the petition in the interest of justice, adverse order that deferred. List after 2 weeks.
My lord, I'm for the petitioner, my
2
lord.
and 3 in this matter.
Praying for a Passover, my lord.
Why?
My
Your
lord,
counsel is never there. He's here in the court today.
yes, my lord, on his leave before the court number 1. Praying for a short Passover, my lord.
Yes, tell me what is it, this
My
matter?
lord, they were supposed to file their affidavit
Yes,
in
my lord, that
reply.
has been already prepared. The document is with the advocate on record, my lord. He will come and serve the copy as well.
But in the meantime, direction may be
Carry the affidavit with you.
I have got instruction that he will come and satisfy your lordship.
Proxy counsel so and so. Same order. Kar do. Keep it after 2 weeks.
it will appear next week, my lord.
Next week. Note 7.
Praying for a Passover.
Why? What happened in this one?
Item number 7 is also
Connected. Same order. 8 also.
yes, my lord.
6, 7 are connected.
No. That is a separate matter.
Same order.
Great, my lord.
Clearance कर दिए. Item number 8.
Lord, item number 8, my lord, I am appearing for the respondent. My lord, lordship kindly see, my lord, on the last occasion, my lord, liberty was granted to the petitioner to file a supplementary affidavit. And my lord, respondent, my lord, was directed to file a composite affidavit in opposition to the petition and supplementary affidavit. But my lord, copy of supplementary affidavit was not served, my lord.
Has not
Was
been
not served, my lord.
Not been served.
Not been served.
You're appearing.
Item number 8, I am being led by Mr. Joyanto Sengupta and service has not been completed. So I have been instructed to take a adjournment for today.
Same order. Next week. Give it
Correct, my lord.
next week. Next week. Item number 9.
Lordship, this is my section 11 application, your lordship.
My lord,
Uh,
I'm
the-
for the respondent IRCTC, my lord.
The petitioner was
Are you
granted.
opposing, Are you opposing the application?
Yes, your lordship, because this is a commercial matter, my lord. There is a contract, my lord.
Lordship
In the
can
contract.
transfer it to the commercial division if your lordship pleases.
Filed it on the commercial division.
Yes, your lord.
Lordship, lordship,
Withdraw it
no,
and file it in the commercial division. Why should I transfer it?
lordship knows the judgment. Your lordship, Balaji, it says that lordship has the discretion to transfer it.
I do have the discretion, but why do you file it on the wrong side?
Lordship,
When was your 21 notice given?
lordship, it is at page 220. Your lordship, volume 2. Volume 2.
What is the date?
5/5/26. 5th May 26. Your
You
lordship.
can withdraw it and file it on the commercial side.
Lordship, kindly transfers it, lordship.
You're well within time. You can do it. Stop this practice.
Lordship can transfer it. The department will transfer it to take action. The number will be
Why do you
changed.
file it on the wrong side?
Lordship, it is by mistake, your lordship. It has been filed, your
It's a
lordship.
matter of right that you can get it transferred.
No, I bow down, lordship.
It's not your matter of
It is a
right.
mistake. It is a mistake on our part, lordship.
Unnecessarily, we burden the registry with this. Learned counsel for the party submit that this matter is a commercial dispute under the Commercial Disputes Court Act, Section 2(1)(c).
Section 2(1)(e). Yeah. C, your lordship.
2(1)(c) of the said act. Let this matter be renumbered and listed on the commercial side within a period of 2 weeks. Keep it after 4 weeks.
Grateful.
My lord, I am praying for adjournment today. Yeah. An advocate appearing in this case is engaged in court number 12.
My lord, I appear on behalf of the petitioner, my lord. Section 11 application. That on the last week, my lord verbally directed to serve a copy of the petition upon the learned advocate general office. My lord, I have served, my lord.
Lordship, I've received the copy. Lordship, I've received this copy last evening. I haven't been able to speak to my officers. This is although there is a section 11 application. However, this is with respect to land acquisition and compensation in respect thereof.
My lord, section 3G.
3G subsection 5. Now, subsection 5 is about appointment by the central government. Lordship, may I just come back any day convenient to Lordship?
It's 3G, then it has to be the divisional commissioner or the.
Yes,
district
Lordship.
magistrate.
I have
In that
already given, no, my lord, I have already given notice. My lord, thereafter, my lord, they have passed it to the department, my lord, till date, no appointment has taken place. My lord,
That's all right.
kindly see, my lord.
That is what 3G is. sir.
Yes, Lordship.
Yes, my lord, that's why, my lord, kindly come to page 39 once, my lord. Kindly come to
Let them
page
take his
39.
section. Learned counsel for the respondent appears and states that he has been handed over a copy of the petition on the last night. It's a new brief. He seeks and is granted time to take instruction. List after 2 weeks. 2 weeks?
More than enough, Lordship. More than enough. Grateful, Lordship.
Appear on page.
Well, in 2 weeks, you'll be able to appoint the arbitrator.
Lordship.
3 weeks.
Lordship, I will use, Lordship, I am the additional government pleader. I will speak to the learned AG, Advocate General. I will,
3 weeks.
Lord,
Lordship.
may I suggest one thing, my lord, by consent of the parties, my lord?
No,
my
Lordship,
lord,
that
yeah.
cannot happen. That
Yes,
cannot
my
happen.
lord, my lord, because, my lord, I will be preferring for a retired honorable judge of this court, my lord. My lord, the matter is hefty, my lord, that's why, my lord.
And then
Yes, my lord. My lord.
Grateful, Lordship.
I got 12.
Lord, I'm for the petitioner, my lord, praying for a Passover.
who's the counsel? He never comes.
A short Passover. He's on his leg before court number 1, my lord.
Give a date. In order to. I really want to see your senior. He never comes.
My lord, item number 13, I appear on behalf of the petitioner, my lord.
Yes.
My lord, the affidavit of service is not ready, my lord. It's being affirmed. It's
Take
been
down.
served. Both petitions have been delivered.
Take down, take down. Learned counsel for the petitioner seeks and is granted 2 weeks time to file his affidavit of service.
Faithful. my lord.
States that the service is not complete. He seeks and is granted.
I appear for the petition in this brief. I appear for the petition in this matter. The service has been affected, my lord, on the respondent number 1, whereas the respondent number 2, my lord, it records the addressee has left.
Get his address, serve him. Procure his fresh address, sir.
But there were 3 addresses. I've served on 2. We have caused service on 2.
Whatever it is, you have to get the address. That's your job. Your client's job, not your job.
No.
He has to get the fresh address.
The thing is, well, we could obtain 3 addresses. One has not been served at, but we will make service on that particular
All right, take down.
address also.
Learned counsel for the petitioner states that the respondent number 2 has not been served. He seeks and is granted 2 weeks time to effect service on
I beg your pardon. Your Lordship.
Respondent number 2 has not been served, right? You're saying he seeks and is granted 2 weeks time to serve upon respondent number 2. That this matter be listed after 3 weeks.
I'm
Affidavit
so
of
sorry,
service.
my lord, this is the respondent number 1.
Respondent number 1.
Service has been effected.
Affidavit of service taken on.
Well, that will be the same, well, in respect of the next matter, well, item number 15. Identical matter, 2 separate agreements.
Who has not been served in that?
Well, 1.
Same one.
Same. Yes, my lord, the affidavit of service, my lord. I'm sorry. Okay. Great. After
16.
This matter, Mr. Dinabandhu Chaudhary is appearing for the petitioner. Due to his illness, he has not come to court. My lord.
Give your appearance. You give your appearance, sir.
17 not.
At least you give your appearance.
17.
I am for the petitioner praying for not today, Lordship.
Why?
Because
today?
my senior is engaged with another court.
There's some holiday today. Oh. Everybody has the same prayer. No, it can't be tomorrow, next week. Okay. Proxy counsel so and so appear and see. Next week.
What are the please?
I am opposing this application.
My lord, this is an application for under section 11 for appointment of arbitrator.
Yes.
My lord, the agreement was executed between the parties. My lord, page 15. My lord, this is a development agreement.
Yeah.
My lord, page 15 is a development agreement. My lord, arbitration clause. My lord, clause 22. My lord, this is an arbitration clause. Page, my lord, 22. Clause 22. That any dispute arising in completion of project and associated with the including cost incurred by the developer or performance of the owner of his part contract or amount payable to the owner in case determination of terms agreement will be referred to two arbitrators to be selected by each party within a month from the date of arising of such dispute, and their decision will be final and conclusive. My lord, dispute cropped up, my lord, that the area of the land and the pond, my lord, the corporation, my lord, did not allow to sanction plan on the ground that this area is a different from the mother deed and the corporation record. As a corporation cleared, my lord, this on 2026 in a January. As such, my lord, the delay. And after completion, my lord, I claim that the original deed be produced because Urban Land Sealing Act, there is a no objection is necessary. My lord, they did not produce. As such, my lord, the dispute arise, my lord, and I referred the dispute before the arbitrator, but my lord, they did not accept. My lord, page 53, my lord, this is an page 53, my lord, invoking the arbitration clause. This is the notice, my lord.
Yes. Yes.
This is
My lord,
Are you disputing the agreement?
no, I'm not disputing the agreement.
Then what is the ground?
No. Two things, my lord. Firstly, my lord, without prejudice to what is stated here in my lord, the nature of the dispute is such that, in my respectful submission, my lord, I believe that this matter ought to be settled or can be settled. So, my
That's
lord, for my
between-
first
that's
prayer
between the
before your
parties.
lordship will be, I beg.
That's between the parties if the
Yes,
matter can
no.
be settled.
Yes, of course. But I was suggesting, my lord, subject to what falls from your lordship, of course, is if the parties could be referred to mediation before the mediation center, my lord. We see, my lord, for a kindly make a time bound 3 weeks, 4 weeks. If
Yes,
it is
sir,
not
right.
done,
If
then we come back to your lordship.
Good suggestion, my lord. Just if the dispute settled, my lord, then
I think this should be settled. But
settled.
in the event it is not, I'll come back to your lordship and I'll agree to appointment of an arbitrator, subject to a couple of
Alright.
observations.
Stayed on. The petitioner has preferred the present application under section 11(6) of the Arbitration Conciliation Act 1996, seeking constitution of an arbitral tribunal for adjudication of the dispute and differences which have arisen between the parties in connection with and arising out the registered development agreement dated 18/2/2022. Full stop. At the outset itself, learned counsel for the parties submit that the dispute can be mutually settled between the parties. They pray for this matter to be referred to the mediation cell to explore the possibilities of an amicable settlement. Let this matter be listed. Be sent to the mediation cell. A senior mediator shall be appointed. Give a date before the court after 4 weeks. Should I give a date before the mediation or they take care of it?
We'll take care of that. We'll nominate somebody through the mediation committee, which is there of the court, my lord, the senior judge.
Mediation center of High Court.
That will suffice, my lord. Grateful, my lord.
The order will be communicated by you.
They can communicate or we can communicate, no difficulty. In any case,
This order shall be communicated by the petitioner so that the mediation center can take necessary steps.
grateful, my lord.
Lordship, item number 19, I appear for the respondent.
Your lordship, I appear for the petitioner. Your lordship, this is section 11 application, your lordship. Your lordship kindly sees.
Who's section 11? Her section 11?
No, Lordship, it is their section 11.
Yes, as a petition. Your lordship kindly sees page 34. We had initially filed a suit. They had filed a section 8 application which was allowed and the suit was set aside and the parties were directed to go for arbitration. At page 39 is the operative part of the order. Page 39, your lordship kindly looks. Thereafter, we have repeatedly written to them. They have not consented to any appointment of any arbitrator. Page 39, your lordship kindly sees. And
Lordship, my objections are
70.
twofold.
Yes.
Lordship, firstly, they have not given us any section 21 notice.
Lordship kindly
And
sees
second,
78.
and
Page 78 onwards.
Lordship, second, this is a commercial dispute. They have filed it on the non-commercial side. The dispute pertains to telecom towers. This is a commercial dispute. They have filed it in the non-commercial side. There was a lease agreement
Not a
between the
21 notice.
Page 81.
Yes,
Also,
page
there is
81 is a legal notice.
81, your lordship kindly sees. They have asked for appointment of an arbitrator. Yeah.
Lordship, in my brief that they have
Section might
served,
not
there is
have been
no
mentioned,
page
your lordship.
81. The
Because this
brief
is a
that
court's
I have
order
got,
also.
They have not received the entire
We
brief.
have sent your lordship.
I
There is
have
a
only
tag report
received
there.
till page
Kindly sees page
47A.
What is she saying? Give a
They
complete.
have come before the learned court below. They have made the section 8. My suit has
Lordship, we
been
are not
started. They have
disputing all
said
those
that it
facts.
Madam, just a minute. It's not a running commentary. Just because you are
Apologize.
appearing online, do you even
I
see when the
apologize,
the other person is talking? You just, what is this?
I apologize, Lordship.
Yes.
Your Lordship, it was their application. We had gone for a suit. It got rejected. Your Lordship has seen page 39.
Yes.
We had given letters 81 and also in page 76. Your Lordship, they have received the track report is there. We are just asking for an appointment of an arbitrator by this court. It's not like we are asking for anything adverse against them. There is a dispute that may be decided by an arbitrator, Your Lordship.
I'm appointing an arbitrator, madam.
Lordship, but we have not, the dispute is commercial in nature. They have filed it on non-commercial side. The
Commercial
dispute,
That,
Lordship, this was with
that I'll have to take a look into.
regard to telecommunication networks.
Telecommunication, they had given us a.
The commercial dispute then in that case.
It may be transferred to the commercial division then, Your Lordship. It was
Lordship, there is
basically
no
we had
pleading for commercial
towers,
dispute
Your
also.
Lordship, towers, telecommunication towers. My land was there, it was given. So it should be in commercial, but
Commercial dispute, then why have you filed it on the
that has the advocate on record. I'll make the necessary changes if such recording can be made, Your Lordship. It just has to be transposed to
Learned
commercial, Your
counsel for the
Lordship.
parties submit that the petition has been wrongly filed on the commercial side, on the non-commercial side. The dispute between the parties is a commercial dispute under the Commercial Courts Act, section 2(1).
2(1).
C.
I'll just look at it.
2(1)C of the Act, the Commercial Courts Act. The Commercial Courts Act, 2(1)C.
C. 1C transaction tenders. 1C, Your Lordship. 1C. 1C9, Your Lordship. Distribution and licensing agreements.
Two 1C9. 9. Roman 9. Let this matter be listed on the commercial side. The registry is directed to renumber the.
Lordship, just one indulgence and request. If we can be served again, because the petition I have got, it has only 47 pages. And my learned friend was referring to page 82.
In a period of 2 weeks, listed on the commercial side. Give a complete set.
I have given the entire service, Your Lordship. I'll again serve. I'll serve again.
Affidavit of service taken on record.
Much obliged, Lordship.
नहीं, 9 नहीं होगा, कुछ और होगा. Different dispute. 2(1)C का.
Your Lordship, is this being fixed on another day?
After 2 weeks.
No.
After 3 weeks. Yes.
What the 20. His application, my lord, I have a preliminary point, but let him argue.
Yes. So I am for the petitioner, my lord, the agreement of mortgage loan was there of 1 crore 30 lakhs. So after 1 year, my lord, they have paid 1 crore 10. And then they agreed, my lord, that the balance 20 lakhs, my lord, they will pay along with the agreed rate of interest. My lord, in spite of the different demand, my lord, that 20 lakhs and as well as the interest, which is now accrued to 58 lakhs, my lord, they are not paying. My lord, there is a clear admission that they will pay in the section 9 proceeding before the court below in the Alipur Court, where I filed the section 9, they have admitted that they will pay as and when that building will be constructed. So, my lord, this is a case. If your lordship come to page 23, my lord, there is a mortgage agreement. And my lord, page 23 is a mortgage agreement, my lord. At 33A, there is arbitration clause. 33A, my lord, Q. There is a arbitration clause by and between the parties.
Clause number?
My lord, 33A is the, my lord, the arbitration clause by and between the party, that is a bottom at a lot. So thereafter, my lord, they have paid 1 crore 10 lakhs out of 1 crore 30 lakhs. 20 lakhs remain unpaid. Now, if your lordship come to page 80, 83, 80, if your lordship come to page 80, yes, my lord, the paragraph 17, this is a affidavit in opposition of my learned friend in the learned court below in section 9 proceeding. My lord, that the statement made in paragraph 13 to 16 of the petition are matter in relation to 1.10 crores to the petitioner by the respondent number 1 and further execution registered deed of release on 19 March 2014, that the respondent had requested the petitioner that they shall refund the balance sum also. This is this 20 lakhs. That admittedly the petitioner has agreed to have received a sum of rupees 1 crore 10 and the balance sum the respondent requested to have the same paid once the construction of the project is initiated and to which the petitioner agreed and also agreed not to take any action against the respondent. So, my lord, this is some admission of my learned friend. So, this 20 lakhs become now 58 lakhs. In spite of, my lord, they are not paying. My lord, I have given them a notice that you pay it, but my lord, they have refused to pay or, my lord, give any at 92. If your lordship come to page 92, this is my notice for agreeing to the appointment of the arbitrator. And page 95 is my claim against them. That is, my lord, coming, if we add all those things in elements, my lord, it is coming to 58 lakhs. So I am praying, my lord, that a fit and proper person be appointed, my lord. Yes.
And perhaps, my lord, this application is not maintainable. Why I tell your lordship, my lord. Firstly, my lord, what I have understood, my lord, this would otherwise squarely fall within, let 216 of the Commercial Codes Act, my lord. So I'm even my lord, like for once, my lord, if I keep it aside, my lord, lordship will kindly see their petition once, my lord, at paragraph at page 8. It is an admitted position, my lord, that the agreement is of 2013. And, my lord, what they say, my lord, paragraph 14, may I read out that portion, my lord? That would be convenient, my lord. Since the dues of the petitioner was not paid and cleared, the petitioner apprehended that the respondents were taking steps to alienate or sale of the said property to third parties, and thereby the interest of the petitioner would be prejudiced. The petitioner filed an application being miss case number such and such under section 9 of the said act. That was done in 2020. At Alipur, there was an interim Order passed on 14th of October 2020, restraining, etc., my lord. And we entered appearance, my lord. We are not disputing on that aspect, my lord. Then, my lord, next paragraph, my lord. In view of the aforesaid, the petitioner by a letter dated 11/2/2020 invoked the said arbitration clause, my lord. 2020. We are in 26. Claim is of 2020. Twofold submission, my lord. Firstly, my lord, and then, my lord, thereafter, my lord, the next continuation of that paragraph on the fourth line from the top, my lord, then he sends another notice which he relies on page 92. That's the 15th of May notice 2024, my lord. If, my lord, I take the strictest, my lord, interpretation of section 9 subsection 2 for clubbed with, my lord, 9(4), my lord, this very recent Regenta Hotels judgment, my lord, 2026, my lord, I will cite that, my lord. If the claim is of 2020, my lord, and assuming that he has initiated, my lord, he, my lord, crosses the bar, my lord, of 9(2), and I take that his my lord, notice under section 11 or rather 21 notice, if I take it as the notice dated 11th of February 2020, he has not initiated the arbitration process. He had initiated but not raised any claim, so the claim is time barred. That's first aspect, my lord. Secondly, my lord, if I assume that 15/5/2024 is the date where he initiates, which he otherwise refers to the earlier notice dated, my lord, 11/2/2020, my lord, even then, my lord, his claim is time barred, my lord, in both the cases, my lord. Either ways, my lord. Because, my lord, he cannot, my lord, espouse, my lord, and there is no admission on our part with regard to the claim, even if there is an admission that is in 2020, he himself says it. Even if I assume that I have admitted in my affidavit in opposition way back in 2020 that yes, that is due and payable, there is no further admission, my lord. So even like the principles, my lord, of admission, my lord, giving a fresh time of limitation of 3 years, my lord, and taking, my lord, the recourse of Article 137 of the Limitation Act, my lord, will not, my lord, squarely help him, my lord, friend, my lord. So this is the practical situation, my lord. Now, my lord, I put this question to myself, my lord, whether this claim can be, my lord, translated into an arbitration proceeding, my lord, which is already a dead claim, my lord. That is all, my lord.
Yes. My cause of action to claim some amount before approach this honorable court, my lord, it will start from the date of denial. Your lordship
It will start from the date when you had sent the notice, which is on 11th of February 2020.
Yes, lordship. But thereafter, my lord, 11th of
thereafter you had done nothing. So it's barred by limitation.
But in spite of that, my lord, they have not denied. So
all
what
right,
is
even
the
if they
parties
admit, if
what
it
is
is
the understanding between the parties, my lord? That can be come out from the
not
arbitration
denied in the
trial.
year 2020.
Yes, my lord. After
That's all.
that, what's happened and why the claimant has not taken up the matter before the court, my lord, that will come out in the trial by and between the parties, and which can be done in the, my lord, the arbitration proceeding itself.
Only if you cross the threshold of limitation, then the question of trial comes up. Here, the 3-year period, we assume that it starts from 2020. Not assume, this is what you say also. Your letter of 15/5 is only in the, and you admit in the letter, read the letter.
Yes, lordship.
It says this notice is in reference to the arbitration clause in the mortgage deed dated so and so, and further in reference to the notice of invocation of arbitration dated 11/2/2020.
Lordship.
So you had invoked the arbitration in 2020.
Lordship.
This is just a subsequent communication which you have issued on 15/5. Barred by limitation.
My lord, from 2020, my lord.
What have you
My lord, thereafter kindly see there is no denial at all. My lord,
There's
even
no
the
question of
notice,
any denial, sir.
because
You have
there is
to,
a, my lord,
you have to
judgment
take
is there,
steps
my
within
lord.
3 years.
No,
It's
judgments are there, my lord. Whether it is a barred or time barred, my lord, it is
It
the
is time barred,
arbitrator,
sir.
arbitrator will decide. There is a no denial. My prayer is that, my lord, there is a no denial. If there is a denial, my lord, your lordship will direct me, yes, there is a 3 years. But when the person is time to time admitting that I will pay, my lord, why the petitioner will?
When was the admission? In 2020.
2020.
After that?
There is a no denial.
So that's what What did you say just now? That he has been admitting.
Yes.
He has only admitted in 2020, and you have taken no steps. So it's barred by limitation.
It is in writing, but
All
my
right.
lord, whether
I'm
there was any
dismissing it. I'm dismissing it on the ground of limitation. You challenge it with all your judgments. Take down.
My lord, my lord, some judgments that they kindly allow me to show, my lord, that the
Yes,
arbitrator.
you take it in the appeal. You show all the judgments.
No,
the appeal.
before your lordship.
You know, you should have come with the judgments. You should have come prepared with the judgments.
Give me 1 day, lordship.
Why should I give you? Your judgments will help you when you file an appeal. Take down. I should dismiss it. I am convinced the petitioner has preferred the present petition under section 11(6) of the Arbitration and Conciliation Act, seeking appointment of a sole arbitrator for adjudication of dispute alleged to have arisen between the parties out of the registered mortgage deed dated 12th February 2013. Full stop. Learned counsel for the petitioner submits that petitioner is a private limited company engaged inter alia in the business of investment in real estate, purchase and sale of properties, and providing financial assistance for development of projects. Full stop. The respondent number 1 is a partnership firm, and respondent number 2 and 3 are its existing partners who are engaged in the business of development of real estate projects. Full stop. It is submitted that the respondent purchased premises number 34 BC, Chedla Road, Calcutta. Yeah. Scheduled property. Chetla. 12th February 2013. Chetla Road, 30. Chetla Road, Calcutta. BNC, Chetla Road, Calcutta, 7000727. के बाद क्या लिखा है? Chetla Road for you had invested the money for the construction.
Yes. My lord, may I disturb one thing? 31A, one clause only. Actual lordship.
Sorry?
31A, one clause only.
131?
A, page
Yes.
31A, one clause only.
Yes.
My lord, that the mortgagor further covenants with the mortgagee herein, that in case under circumstances, if the mortgagor herein is not able to complete the construction of new building upon the said property, and the said work of construction is still unanimously for indefinite period,
Yes.
then under these circumstances, the mortgagor shall refund the total principal amount paid by the mortgagee herein from time to time together with the interest of 18% per annum. My lord, it is not coming. Limitation not saved.
All right. That's why I said challenge it. क्या लिखा है? For construction of a residential and commercial units over the said property. Full stop. Learned counsel for the petitioner submits that in connection with the development project, the petitioner advanced financial assistance to the respondent and paid a sum of rupees 1 crore 50 lakhs. 1 crore 50 lakhs, right?
1 crore
1 crore 30
1
lakhs.
crore 30, 1 crore 10 paid.
1 crore 30 lakhs.
30 and
Yes.
paid 1 crore 10. So 20 remain unpaid.
1 crore 30 lakhs, but had made a payment of 1 crore 10 lakhs. In consideration thereof, the parties executed the registered deed of mortgage dated 12/2/2023, whereby the respondent agreed to mortgage an undivided one-half share in the said property in favor of the petitioner. Half share in favor of the petitioner. Full stop. It is further submitted that in terms of the said agreement, the amount advanced by the petitioner was to be repaid within 36 months with an interest at the rate of 18% per annum. Full stop. Accordingly, the petitioner, according to the petitioner, the respondent repaid the principal amount, and consequently a deed of release came to be executed by the petitioner in favor of the respondent, dated 19/3/2014. Full stop. Learned counsel for the petitioner submits that the respondent, that an interest component of rupees 58,55,366.46 remains outstanding to be paid by the respondents. Full stop. The petitioner submits that in order to secure the alleged outstanding dues, the petitioner approached the court of the learned district judge at Alipur by filing a Section 9 petition under the Arbitration Conciliation Act 1996 and had obtained an interim order dated 14/10/2020 in miscellaneous case 32 of 2020. It is the specific case of the petitioner that in terms of clause 6 of the mortgage deed dated 12/2/2013, the petitioner had invoked arbitration by issuing a notice dated 11/2/2020. Full stop. Thereafter, the petitioner, by a further letter dated 15/5/2024, proposed the name of the arbitrator. Full stop. Learned counsel for the petitioner submits that despite receipt of such communication, the respondent had failed to resolve the dispute between the parties and repaid and did not pay the outstanding dues, compelling the petitioner to approach this court by way of this petition. Full stop. Learned counsel for the respondent states that the present petition is barred by limitation since the petitioner had invoked the arbitration clause by issuing a notice under Section 21 dated 11/2/2020. Full stop. The said communication, he further points out that the said communication is not on record. Full stop. Learned senior counsel for the respondent, senior advocate Mr. Rizul, states that the letter dated 15/5/2024 issued by the petitioner itself acknowledges the fact that the notice invoking arbitration was issued on 11/2/2020, and thus the present petition is barred by limitation. Anything else?
Even if we take the COVID part into account, even then it's time barred. 28th of February 2022, the Supreme Court,
why get into that?
I'm just saying that, even then, it's.
If you want me to record it, you tell me.
I'm sorry,
I'm recording your submissions. What do you want?
Up to your lordship, because they may take a point of COVID, although the notice was pre-COVID, even then, if we take the sanction granted by the full bench of the Supreme Court till 28th of February 2022, even then it is time barred,
Even assuming that the benefit of the COVID period is given to the petitioner, still the present claim will be time barred. Full stop. Heard counsel for the petitioner and having perused the materials placed on record and after hearing the counsel for the parties, This court is of the view that the pleadings and documents disclosed by the petitioner, specifically the notice dated 11/2/2020, as the notice invoking arbitration under Section 21 of the Arbitration and Conciliation Act 1996, is not on record. Full stop. However, significantly, the said notice, significantly, the said further communication dated 15/5/2024 itself acknowledges the fact that the petitioner had issued the Section 21 notice on 11/2/2020 and had invoked the arbitration on the said date. Full stop. This fact is not disputed by the petitioner. Full stop. It is now well settled that an application under Section 11 of the Arbitration and Conciliation Act is governed by the law of limitation and is required to be filed within 3 years from the date when the cause of action to seek appointment of an arbitrator accrues, namely the failure of the opposite party to act inconsistent in the failure of the party to act in pursuance of the said invocation of the arbitration agreement makes the claim time barred. In the present case, it is evident that the petitioner had invoked the arbitration proceedings while its notice under Section 21 dated 11/2/2020, and thus the present claim is beyond the period of 3 years and is barred by limitation. In view of the same, the present petition is dismissed.
Obliged.
21. No, I am for the petition in this matter. What is my application formula section 11? With regard to the agreement for sale of 18th of January 2023. With regard to the sale of immovable property. The agreement that is at page 12 and the agreement clause at page 17, paragraph number 13. Page 17, paragraph number 13. Differences in arising out of the relation to the agreement for sales and shall be avoided under the provision of arbitration and conciliation 1900 as amended from time to time. The award was shall be final binding upon the party. Thereafter, I served the notice on 23rd of February 2026, that is at page 23, and they replied on 18th of March 2026.
Page 24, I think.
24, the notice, 23rd of February 2026, and they replied, my lord, that is at page 27. By
It's not your Section 21 notice.
Section 21 notice, my lord.
Where have you stated it's a Section 21 notice? Where have you invoked? Show me. Which paragraph, which page? Where?
That was not specifically spelled out in the notice, my lord.
Then I should assume it.
My lord.
You want to withdraw it, file afresh, giving a Section 21 notice, or you want me to dismiss on this ground? What do you want?
I shall file fresh, my lord.
Learned counsel for the petitioner seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law.
How is the liberty to, my lord, issue not?
Obviously, I'm giving the liberty. अच्छा ये अजून काय बाकी?
I know 22.
Lordship, in this matter, I am for the petitioner led by Mr. Ritoban Sarkar. He is on his legs in another court, praying for a short Passover, Lordship.
You can do it. What is the matter?
Lordship, he is in this. He is in the matter, Lordship.
You have read the
Lordship,
brief?
in last occasion, there was a order to publish because we were not able to serve the respondents. So the publication has been made.
What application is this?
Lordship, this is this is a dispute regarding the hire purchase matter. It was done.
Keep it next week. What is a GA?
Not sure.
It's all right. Next week. At least read the files, madam, so you can assist.
This is my section in petition. Actually, the petitioner is an owner and a developer of a premises. Now, this project was developed into two phases, phase 1 and phase 2. Now, inside phase 1, there is a club called Club 360, which is owned by the developer, being the petitioner. And the clauses between the parties clearly says that the owners of phase 2 will have every access to the club like phase 1 owners. It's a 5-star club with all gymnasium, swimming pool, everything, all facilities for the members and occupiers of the flat of the property. Now, what has happened here is an association was formed by the flat owners of the residency in 2023, only for the purpose of upkeep and maintenance of the building. And 2025, there was an agreement entered into between the developer, the owner, and the association, by which this upkeep and maintenance, this responsibility of maintaining the property was handed over to the respondent registered association. Now, the agreement between the parties clearly states that we will be the owner of the club and phase 2 people will have access through a gate, through a common pathway into the phase 1 where the club is situated. Now, what has happened? The phase 1 owners, this association is restraining the access of the owners of the phase 2 owners into the club premises. So the agreement clearly says that they will never restrain the access and the club membership and the ownership will remain with me. The only person who can block the access is the petitioner. It's me, being the owner. Now, what initially there was an open space. Now they have put temporary blockages and the brick structure has also been constructed. Now the owners of the phase 2, who has given 80,000 rupees for getting the membership in the club, and they also have equal access like the owners of phase 1, they are writing it to me that kindly take steps so that we can have an access with the club. The agreement also says that apart from the fact that phase 2 owners will have access, I can also invite membership from outsiders. Now, the fact is that since they are restraining the access, we are not able to operate our club. We are not able to get any subscription from outside members, and also the phase 2 owners who have direct access to the club, they are not able to access. So my club is non-operational. Now, as on date, Your Lordship, I have filed a Section 9 petition only with a limited period that they should be restrained from blocking the access so that the club premises can be utilized. The club belongs to me. It is not the association's club. They are only for the maintenance of the building. Now, Lordship will only first come to the clauses which I will show. If Your Lordship kindly takes page 37 once. This is one of the agreement which I have annexed with the flat owners to show that what facilities they will have. They will enjoy in the club. Before that, my lord will kindly take 36, clause 12.1. Club facilities. After completion of the sale of the said flat, the purchaser shall be entitled to apply and shall get non-transferable membership valid till the purchaser remains the owner of the said flat of the club 360 and unit consisting of various facilities such as swimming pool, gymnasium, games room, coffee shop owned and managed and maintained by the seller. Seller is my client, Your Lordship, the petitioner. Subject to the purchasers agree and accepting to the terms and conditions of the club. Now, Your Lordship will take the next page. 12.4, clause 12.4. It is further clarified that the membership of the Club 360 shall be mean only the right to use and utilize the facilities provided by the club, and the purchasers shall not claim any kind of right of ownership of the Club 360 in any manner whatsoever. So these are the restricted right of the members. The sellers may, next clause, the sellers may enroll or invite new members for membership of the Club 360 other than the members of the Green Heights Housing Complex in the manner and on the terms and conditions as it deems fit and proper, and the purchasers shall not raise any kind of objection with regard to this. Now, your lordship will see next clause, your lordship, page 39, clause 13.7. The purchasers, upon full satisfaction and with complete knowledge of the common portion specification and all other ancillary matters, is entering into this agreement. The purchasers have examined and is acquainted with the said complex to the extent already constructed and to be further constructed, and have agreed that the purchaser shall neither have nor shall claim any right over any portion of the said complex and the residential premises save and except of the said flat and appurtenances. Now your lordship will take the next agreement. This is an agreement with the phase 2 owner, similar clauses. Your lordship will take page 112. If my lord is pleased to take page 112, the agreement with the owners of the phase 2 starts. I have annexed one of the copies therein to show the facilities and the rights that the occupiers have with regard to the club is concerned. Volume 2, my lord. Volume 2. My lord will kindly straight away take the agreement starts from 112. My lord will take page 138. Yes. Clause 35.13, my lord. I was referring to. My lord has got it. Notwithstanding anything elsewhere to the contrary herein contained, it is expressly agreed and understood that the promoter is the client, my client, shall be exclusively entitled to and shall have exclusive right of perpetuity to install its own grow signs and signs at the main entrance of the housing complex, the ultimate roofs of the buildings, club entrance without any fee or charge, and or to install any and permit any person to install towers, VSAT, dish or any other antennas or installation of any nature on the ultimate roofs for the time being of the buildings, blocks or any part thereof on such terms and conditions as the promoter may in its sole discretion think fit and proper without any objection or hindrance from the allotee, and the allotee hereby consents to the same. The promotee shall also be entitled to enter upon the housing complex or any part thereof with or without main materials vehicles. Now your lordship will take the next clause at page 161, clause 5. This is the sale deed. Clause 5, my lord. The use of the common areas including but not limited to amenities and facilities shall be borne by the allotee using due care and caution, and the role of the promoter shall be only to provide the initial infrastructure in respect to common areas, including the amenities and facilities, and appoint agencies for maintenance of the same. The allotee shall not hold the owners and promoter liable for any manner for any accident or damage while enjoying the common areas, including club facility by the allotee of his family members or any other portion. So, lordship, every occupier, whoever is there residing in the property, will get membership against each flat, and they will enjoy the club facilities. Now, your lordship will see what has happened in 2023 after the association was formed. 2025, the association was handed over the responsibility for maintenance of the building. That agreement is at page 169, which in arbitration clause I am referring to. This is the agreement, Your Lordship, out of which disputes have arisen. 21st of August 2025. Your Lordship will see the parties Loharuka Projects Private Limited. It's my client. And Your Lordship, next page 170. Loharuka Green Heights Association of Apartment Owners is the respondent. Now, Your Lordship will see the last clause at page 170. The recital. The developer has constructed and completed a club building inside the LGH. LGH is Lordship Loharuka Green Heights. That's the name of the complex. And has designed, developed certain facilities therein, including gymnasium, swimming pool, games room, banquet facility, yoga room, cards rooms, such and such. The developer owns the club building. Then, after construction and completion of LGH, the developer has handed over the vacant peaceful possession of the sold flats units to the respective flat owners of LGH, hereinafter referred to as the flat owners. Then, Your Lordship, the clause thereafter, just before now the handing over. As on date, the association has been duly formed and registered by the flat owners for the purpose of maintenance, operation, and administration of the common facilities. So this is the only purpose for which it was formed. And Your Lordship, just the clause above that, Your Lordship, I missed out. As per the terms of the agreement with the respective flat owners of LGH, all flat owners, unit holder of LGH has made members to use and utilize all the amenities developed in the club building. The flat owners will also be mandatorily become members and utilize all the amenities developed in the club building. Now, Your Lordship will take page 172, clause 3 and 4. These are important, Your Lordship, for the section 9. The association hereby agrees and allow free, uninterrupted, but governed ingress and egress to the residents, shall service providers and invitees of LGH2 to use and utilize the existing internal roads, pathways, and access points of LGH. The association and all of its members shall not hinder and or obstruct to all residents, members of LGH2 to get access to the club building through the access point of LGH. Similar free, uninterrupted, but governed access to LGH2 internal roads, pathways, and access points will be provided to the residents, staff, service providers, and invitees of LGH. Use of club building. The resident flat owners of LGH and LGH2 will both enjoy the amenities and facilities of the club owned by the developer, subject to payment of applicable user charges and adherence to rules and regulations as has been made by the developer from time to time. In case the residents of LGH and LGH2 do not make timely payments of user charges and decline to pay the same at any point, the developer finds it difficult to maintain and run the services offered. The developer shall have right to withdraw the services of the members of the club. So, Lordship, these are the clauses, Your Lordship. This is the registered association is exactly acting in violation and in divorce of these two conditions under the handing over agreement by not allowing access to the owners of the LGH to the occupiers of the phase 2. And Your Lordship, they have also put a blockade on the common pathway so that they cannot have an access. The only right, the developer has the only right to restrain someone from accessing the club if they don't pay the periodical monthly charges. It is not the association. Association only for the maintenance of the building. Now, Lordship, kindly see what has happened thereafter. We have made pleadings in the section 9 that they are not allowing access. Now, after filing the section 9, Your Lordship, in the interregnum period, various owners of phase 2 has written letters to us that we are not able to access the club. Kindly remove the blockade so that we can also enjoy the facilities like the phase 2 owners. Because the agreement I will show, they have paid rupees 80,000 for getting the membership of the club, which they are not able to enjoy. If Your Lordship kindly sees the supplementary affidavit which you are filing it on record, we have served it up on the other side.
What is the
supplementary affidavit? Only shows the photographs of the blockage and the emails. We have served it up on the others. My Lord, will kindly see page 6 first of the supplementary affidavit.
And how many access you have to the club?
Sorry, Your Lordship.
This is the only access.
This is the only access. It's a common pathway through phase 1. Phase 2 and phase 1 are situated adjacent to each other. This is the only common pathway. Your Lordship, I will show the map as well. Your Lordship, kindly first takes page 5. Your Lordship, kindly see this is the common pathway which was initially open when the construction was made. Page 5 of the supplementary.
Page 6.
Sorry, page 6.
Yes.
This was initially open. This is the common pathway from phase 2 and phase 1. Now your lordship will see page 6. Sorry, page 7. Very sorry. Next page. This is the, kindly see the temporary blockade which has been.
And where is the club?
Installed. Lordship, the club, your lordship, I have given a map. In the map, your lordship will be able to find. The photograph I have not there, but your lordship will see the map at page 223, volume 2 of my petition. Yes. Lordship, page 223, if your lordship sees, there is written in small letters, your lordship, access right through the club premises. And your lordship, the club is on the top. This is a map prepared by the architect, your lordship, when the construction was made. The club is at the top, your lordship will find.
And where is the blockade?
And your lordship, the blockade, your lordship will find it is written in small letters between, just beside block A, access road to the club. Access road to the club. There is.
So the first green light which came up is the left hand side, right?
Yes. First, phase 1 was constructed, LGH. Thereafter, land for LGH2, the phase 2 was acquired. Thereafter, it was constructed adjacent to each other. And this is the access road, in support of which, your lordship, I have shown the photographs. Your lordship, once I can show the photographs of the club as well. It's not there with me, but I am the owner, your lordship, I am in possession. So I can show the photographs of the club. Your lordship, this is the photographs in the supplementary affidavit. Your lordship sees this temporary blockade which has been created. So they are not able to access. Now your lordship will see the emails, only 2 emails of the flat owners of LGH2. I will show your lordship page 10 of the supplementary affidavit. Lordship, page 10 might see. This is 18th of April. The flat owner is writing to the petitioner, I have taken possession of my flat B606 in December, but unable to access the clubhouses, as there is a barricade between the same to access the same. Then my lord will take page 14. Thereafter, repeated emails are there. Page 10, 11, 12, 13 by different flat owners of phase 2. Page 13, my lord will see. 19th April. I am writing it to formally 19. Page 13.
Yes.
I am writing to you formally to bring your attention to serious issue regarding the access to the Club 360, which is designed a common facility heights in phase 1 and phase 2 for the last 4 months. The access path between phase 1 and phase 2 leading to the club has been blocked. The current blockade prevents us, phase 2 residents, from utilizing the services we have rightfully paid for. We request you to immediately intervene and resolve this dispute. Then page 14, your lordship, emails on similar lines by another flat owner that this blockade is there and we are not able to access. Your lordship, if your lordship takes one more clause, page 150, to show that how much money these flat owners in phase 2 has paid for this membership. Page 150, clause 10.2. Okay. My lord will see. Mandatory membership of Club 360. Membership charges lump sum of rupees 80,000 payable to the promoter besides one-time membership charges as aforesaid. The allotee shall also pay all the charges to be used by Club 360 directly to the Club 360 and will comply with the rules and regulations. So this is the money which they have paid. There one common letter which was sent by various flat owners. This is page 16. Page 16 of the supplementary affidavit, 18 February 2026. Almost, your lordship, 30 flat owners have made this grievance to us regarding the denial of access. Page 16, 18 February 2026. more than 30 flat owners that they have paid money, they are not able to access because of this block. My Lordship, I am only here, Your Lordship, that they should not restrain the phase 2 owners from accessing the club. That is the only, because they will not be prejudiced by this. They are only an association for maintenance. They are not the owners. So if they give access, none of their rights will be prejudiced because they do not have any right of ownership. Now, Lordship, the point of the objection which my learned friend might take, because that he hinted on the last date when the matter was taken up, that this court does not have jurisdiction. Your Lordship will see the agreement once. The venue, Your Lordship knows now this recent trend of judgment, venue is akin to seat. Venue is in Kolkata. The parties are situated outside the origin site jurisdiction of Kolkata. The property is near Rajarat. But the venue is in Kolkata. Venue is akin to seat.
You should go to the commercial court at Rajarhat then.
No, Your Lordship, that is what, Your Lordship. The venue is in Kolkata, Your Lordship. The jurisdiction remains with the Calcutta High Court. Your Lordship, I will, because Your Lordship, the Kolkata is a district so far the origin site is concerned, Your Lordship. There are 3 districts, Your Lordship.
Property is situated in Rajarhat.
But Your Lordship, it is not a suit for land.
That's no, I know that's why it's not a suit for land.
No, that's why I'm saying, since it is not subject to cash, Your Lordship, since it is not a suit for land, and I will be seeking specific performance of this agreement, only to act in terms of this agreement. And Your Lordship, the venue is in Kolkata, Your Lordship. Now, starting with now the latest judgment of the Delhi High Court as well following. Once the venue is decided, it is akin to seat. Section 61, Section 16 to 21 of CPC will not apply. Because Your Lordship, with regard to any property dispute which concerning immovable property is covered under Section 16 of CPC. In this mobile, and thereafter all subsequent judgment says that 16 to 21 will not apply at all once the venue is decided, because party autonomy has to be given importance. Lordship, if required, I will cite those judgments, but 16 to 21 will not apply. So 16 says any dispute with regard to the immovable property where this property is situated, I will have to go there. And Your Lordship, Kolkata, once it is decided that Kolkata will be the venue and courts in Kolkata will have jurisdiction, Your Lordship, our Calcutta High Court has said that Kolkata means the origin site jurisdiction of Kolkata, not any other district. Because 2-1, Your Lordship knows the principal civil code of the district. Here, the property situated in Rajarat, there the principal civil code will be not 24 paraganas. So commercial court at Rajarat. This is not a commercial dispute, but we have to go to the Lordship is referring to district judge at Barasat. That is not 24 paraganas. But once it is referred Kolkata as a district, Your Lordship, then Your Lordship, it will be governed within the origin site jurisdiction, because Kolkata is a district. So far the jurisdiction of the courts are concerned. Like in Alipur, it is South 24 paraganas, Rajarat, Barasat, it is not 24 paraganas. So Your Lordship, Kolkata will have this Calcutta High Court will have jurisdiction in view of the exclusive jurisdiction clause and also Your Lordship in view of the seat clause.
Anything else?
No, Lordship, I will cite. If Your Lordship is not satisfied, I will cite. First, let me show Your Lordship the arbitration clause 1. Page 173. What is it? Clause 7. Any dispute arising out of and or in connection with the agreement shall be first attempted to be resolved amicably, failing which it shall be referred to arbitration under the arbitration council. The venue of the arbitration shall be at Kolkata. Courts at Kolkata shall have exclusive jurisdiction. So once Your Lordship, these 2 clauses are there, Your Lordship.
Legal argument after I come back.
Yes.
Yes.
The first judgment of this I will cite 2017 7 SCC 678.
Affidavits have been exchanged. No.
Reported judgment.
But I'm asking my learned friends to give me at
I
least
don't have a copy. It's a reported judgment. I should have, but I don't.
The practice is different, my lord. Here, my lord, this is not how, my lord, this is, my lord, what my
Get
learned.
one copy.
Very well, my lord, I'll take it out. But
Soft
my lord,
copy I'm
this is
forwarding it.
unfortunate.
This is not unfortunate. Using the tab, I can provide the soft copy here and now.
When I asked him for a copy, he's saying that
You should
I
give
don't
a-
have it right now.
No,
That's
but you should carry one extra copy for the other
no,
side.
I should have my.
What is the practice here? Not to give.
No,
a-
it is. But my junior is not carrying. I am very sorry, Your Lordship, for that. I asked for an extra copy.
That's what I know.
No, I am very sorry for that. Should have carried. I am very sorry, Your Lordship. Very embarrassing situation.
Give the citation.
Yes, 2017 7 SCC 678. Now kindly take first para 1 of this judgment. Leave granted, the present appeal arise an interesting question as to whether, when the seat of arbitration is in Mumbai, an exclusive jurisdiction clause stating that courts at Mumbai alone would have jurisdiction in respect of disputes arising under the agreement would oust all other courts, including the High Court of Delhi, whose judgment is appealed against. Your Lordship, para 11. In an instructive passage, this court stated that an agreement as to the seat of arbitration is analogous to an exclusive jurisdiction clause as follows. Thus, it is clear that the regulation of conduct of arbitration and challenge to an award would have to be done by the courts of country in which arbitration is being conducted. Such a court is then the supervisory court possessed with the power to annul the award. Then Your Lordship will take para 13. This court reiterated that once the seat of arbitration has been fixed, it would be in the nature of an exclusive jurisdiction clause as to the courts which will exercise the supervisory powers over the arbitration.
But this matter, the seat is not fixed, right? The venue,
Sorry, Your Lordship.
the seat has not been fixed here.
Your Lordship, the venue is in Kolkata. Now the BGS Soma is saying that if the seat is not there, venue is also fixed. Venue is akin to seat. And all other subsequent judgments are that. Your Lordship, I will cite those. That venue is akin to seat. Then Your Lordship, the next para 14 in Reliance Industries versus Union of India. This statement of the law was echoed in several paragraphs. The judgment makes it clear that juridical seat is nothing but the legal place of arbitration. It was held that since the juridical seat or legal place of arbitration was London, English courts alone will have jurisdiction to decide the matter. Then Your Lordship will come to para 18. The amended act does not, however, contain the aforesaid amendments, presumably because Balco judgment in no uncertain terms has referred to place as jurisdictional seat. For the purpose of section 2, subsection 2 of the Act, it further made it clear that section 20, subsection 1 and section 20, subsection 2, where the word place is used, refers to juridical seat, whereas in 20, subsection 3, the word place is equivalent to venue. So place is equivalent to jurisdictional seat and place is equivalent to venue. This is being settled law. It was found unnecessary to express and incorporate what the Constitution bench of the Supreme Court has already done by way of construction of the Act. A conspectus of all the aforesaid provisions shows that the moment the seat is designated, it is akin to an exclusive jurisdiction clause. On the facts of the present case, it is clear that the seat of arbitration is Mumbai, and clause 19 further makes it clear that jurisdiction exclusively vests in Mumbai courts. In our case also, the jurisdiction clause is there with the Kolkata court. Under the law of arbitration, unlike the CPC, which applies to suits filed in courts, a reference to seat is a concept by which a neutral venue can be chosen by the parties to an arbitration clause. A neutral venue may not be in classical sense of jurisdiction. That is, no part of cause of action may have arisen at the neutral venue, and neither would any of the provisions of section 16 to 21 be attracted. In arbitration law, however, as has been held above, the moment seat is determined, the fact that the seat is in Mumbai would vest Mumbai courts with exclusive jurisdiction for the purpose of regulating arbitration proceeding arising out of the agreement between the parties. On this proposition, that is what I cited and submitted. Section 60 governs that if there is a dispute, even though this is not a case where the dispute relates to immovable property, but even that is assumed, if a dispute relates to immovable property, 16 to 21 is there in CPC engrafted for suits, but in arbitration moment, a seat is designated, that is exclusive jurisdiction clause. So in respect of that, even if there is a dispute with regard to immovable property, if the arbitration clause says there is a seat, the courts within that jurisdiction will have exclusive jurisdiction. If your lordship first kindly takes one section 16, which I was referring to.
Section 16 of
CPC, your lordship. Because section 16 governs suits with relate to immovable property. It says that where the property is situated, the suit will be filed therein. Your lordship has got section 16. Your lordship will see it starts with suits to be instituted where the subject matter is situated. Your lordship will take D for determination of any right or interest with regard to the immovable property. Or A is for recovery of immovable property. So lordship, assuming that this is a dispute with relate to the suit, it's a immovable property, then also once the seat is in Kolkata, Rajarhat Court, which is the district court of North 24 Paraganas, will not have jurisdiction. Only Kolkata courts will have jurisdiction. Lordship, anyways, this is not a suit relating to the dispute over property. This is a suit with relate to breach of the agreement. So immovable property dispute does not lie. And lordship, the next judgment is that to show that seat is akin to venue. Lordship, this is 2020 volume 4 SCC 234. My lord will first take para 61. Para 61 I am referring. Yes. It will thus be seen that wherever there is an express designation of a venue and no designation of an alternative place as a seat, combined with a supernatural body of rules governing the arbitration and no other significant contrary indicia, the inexorable conclusion is that stated venue is actually the jurisdictional seat of the arbitration. So here, my lord, seat is not there, but the venue is there. And it said Kolkata courts will have jurisdiction, so that is the seat. It is akin to seat. Next paragraph, your lordship, I am referring to paragraph 82 of this judgment. Para 82. On a conspectus of the aforesaid judgments, it may be concluded that.
Sorry, para which? Para?
82, sorry, my lord, 82.
Yes.
On a conspectus of the aforesaid judgments, it may be concluded that whenever there is a designation of a place of arbitration in an arbitration clause as being the venue of the arbitration proceedings, the expression arbitration proceedings would make it clear that the venue is really the seat of the arbitral proceedings, so far as the aforesaid expression does not include just one or more individual or particular hearing, but the arbitration proceeding as a whole, including making of the award at that place. This language has been contrasted with the language such as tribunals are to meet or have the witnesses, experts, or the parties where only hearings are to take place in the venue, which may lead to the conclusion, other things being equal, that the venue so stated is not the seat of arbitral proceeding, but only a convenient place. Further, the fact that the arbitral proceeding shall be held at a particular venue would also indicate that the parties intended to anchor arbitral proceedings to a particular place, signifying thereby that the place is the seat of the arbitral proceedings. This, coupled with there being no other significant contrary indicia that the stated venue is merely a venue and not the seat of the arbitral proceeding, would then conclusively show that Such a clause designates a seat of the arbitral proceedings in an international context if a supernatural body of rules is governing the arbitration. Now here, Lordship, there is also no contrary indicia that any other court will have jurisdiction or there is a seat in some other place. That is not there in the agreement. It says Kolkata is the venue, Kolkata courts will have exclusive jurisdiction. And Lordship, following these judgments, Your Lordship, there is Supreme Court has delivered in 2023 1 SCC 693. What judgment now? এটা কত এটা? Oh. Viola 2023 1 SCC 693. First, my lord will kindly, I'm inviting my lord to paragraph 16 once. Noticing the above interpretation, a three-judge bench of this court in BGS Soma versus NHPC Limited has observed that the expression subject to arbitration used in clause E of subsection 1 of 2 of the Act cannot be confused with the subject matter of the suit. The term subject matter of the suit in the said provision is confined to part 1. The purpose of this clause is to identify the courts having supervisory control over the judicial proceeding. Hence, the clause refers to a court which would be essentially a court of seat of the arbitration process. Accordingly, clause E of subsection 1 of section 2 has to be construed keeping in view the provisions of section 20 of the Act, which are in fact determinative and relevant when we decide the question of the seat of arbitration. This interpretation recognizes the principles of party autonomy, which is the edifice of arbitration. In other words, the term court as defined in clause E of subsection 1 of section 2, which refers to the subject matter of the arbitration, is not necessarily used as finally determinative of the court's territorial jurisdiction to entertain the proceedings under this Act. So it is the party autonomy which has to be given paramount importance. Then Your Lordship will kindly take para 23 of this judgment. It may, however, be noted that clause E of subsection 1 of section 2 be amended by inserting clause 2 with a specific objective to solve the problem of conflict of jurisdiction that would arise in cases where interim measures are sought in India, in cases of arbitration seated outside India. In the context of domestic arbitration, it must be held that once the seat of the arbitration has been fixed, then the courts at the said location alone will have exclusive jurisdiction to exercise the supervisory powers of arbitration. The courts at other locations would not have jurisdiction, including the court where the cause of action has arisen. So this is very clear that other courts will not have jurisdiction. As observed above and held in BGS, SGS, Soma and Indus Mobile, the moment the parties by agreement designate the seat, it becomes akin to exclusive jurisdiction. It would then vest the court at seat with exclusive jurisdiction to regulate the arbitration proceeding arising out of an agreement between the parties. So other courts' jurisdiction are taken away once the parties decide that what will be the venue of this seat. Then, Lordship, all these judgment has been followed by a latest Delhi High Court judgment. This is Moonwalk Infra Project. 2025 SCC Online, Delhi 2797. I will kindly have a look at my copy because Junior has not even brought an extra. Very sorry, my friend. Para 2, 8, 9 and 11. 2, 8, 9 and 11. They are providing. I'm very sorry, my friend. When you see para 2, 8, I have noticed it. Lordship's, my handwriting is there. This is also, it says that seat is akin to venue. If there is no seat fixed separately and venue is there, Venue will have exclusive jurisdiction. And all other courts will not have jurisdiction. The clause is also similar to our agreement. Yeah. Okay. Okay. এটা বলবো তো। Okay. জানি।
Yes.
Now, Supreme Court has recently delivered another judgment. It says the support seat, venue, or place is nothing is mentioned in the agreement. And if the jurisdiction clause is there, my case also the jurisdiction clause is there, then also other courts will not have jurisdiction. Once the parties decide what will be the jurisdiction, giving paramount interference to the party autonomy. So I will also a bit handwritten, Your Lordship, extra copy. I'm just, Your Lordship allows me, I will.
Give me the.
Very sorry. 2025 SCC online, Supreme Court 3069, para 3, 7, and 8. He says that only if the jurisdiction clause is also mentioned without seat venue, jurisdiction clause will have exclusive jurisdiction. 3069. 378. Oh, that's good. You do that then good for after all. Yes, এটা থাকলে এটাও রাখতে পার দামোদর ভ্যালি। Yes. And now this is with regard to jurisdiction. Now, if the clause says that Kolkata courts will have jurisdiction, now what is the definition of Kolkata? Your Lordship, this issue has earlier arisen in a Calcutta High Court judgment. This is 2020 SCC Online Cal 1790. It says that Kolkata means within the ordinance jurisdiction, Calcutta High Courts or City Civil Court, because other districts are not 24 paraganas and South 24 paraganas. Kolkata is a district in itself. 1790. Kindly first take para 2 of this judgment. The respondent has raised the point of maintainability of the application on the ground that this court does not have territorial jurisdiction to entertain this application, as would be evident from the pleadings and documents, as also the relevant provisions of the Arbitration and Conciliation Act. Now she will take para 4 thereafter. Mr. Banerjee, such and such learned counsel for the petitioner places emphasis on the conduct of the respondent in failing to pay the lease rental which caused the petitioner to approach the court. Counsel submits that the averments in the petition clearly to the effect that the cause of action has arisen within the jurisdiction of this court, and that the jurisdiction clause in the agreement as well as the seat of arbitration in the relevant clause is closed with this court with the jurisdiction to deal with the dispute. Swasti Gases Private Limited to submit that if parties have consented to a particular court and if that court otherwise has jurisdiction, then the court would be entitled to adjudicate the disputes. Then Your Lordship, Indus Mobile referred. Indus Mobile is placed to submit that where the parties consented to accept a particular citus of the arbitration, that citus would confer jurisdiction of the court under section 2(1)(e) of the arbitration. It is submitted that once the parties have chosen Kolkata as the citus of the arbitration, this court being the highest civil court having ordinary original civil jurisdiction in a district of Kolkata under section 21E1 of the 2015 Act is the only court which is competent to receive and try and entertain the disputes between the parties, then BGS Soma referred, Hindustan Construction referred, are shown to us that the seat of arbitration would determine the jurisdiction of the court, which can resolve, try and entertain proceeding under 20. Then, Your Lordship, para 5, I have considered the arguments of the council to put the point of adjudication in perspective. The petitioner urges that this court has jurisdiction to grant relief in this application under section 9 of the Act, while the respondent says that this court does not, as no part cause of action is arising. In para 11, para 14, my lord will see the arbitration clause, which was there up for adjudication. The exclusive jurisdiction and venue arguments are being separately dealt. Clause 18K, the exclusive jurisdiction clause is set out. This agreement shall be governed by and constituted in accordance with laws of India. Parties agree to submit to the exclusive jurisdiction of the courts in city of Kolkata. And Your Lordship will take para 19. The petitioner's argument is that since the parties have designated Kolkata as the chosen site of arbitration, this court is the highest civil court, being the requisite jurisdiction under 21E, one of the Amendment Act, and would hence be the only competent court to receive and entertain the present application. Notably, clause 89 fixes Kolkata as the venue of arbitration proceeding as opposed to the seat. Although, for the purpose of the present matter, the factum of the cause of action has arisen within the jurisdiction of this court marks the territoriality issue in favor of the petitioner, and the seat of the arbitration becomes secondary and alternative to the first argument. This court wishes to dwell briefly on the seat point. The Supreme Court has explained that difference between the venue and seat in several decisions, where the formal was seen as the venue place, which could have been fixed for holding of the meetings of the arbitration according to the convenience of the parties, and could hence be changed as and when the parties deem it fit. The expression seat, however, had a connection with the local law, which would be the governing law for the conduct of the arbitral proceedings. Hence, seats remain rooted to the place agreed between the parties in the clause pertaining to the arbitration, since it has a bearing on the applicable courier law governing the conduct of the proceedings. The interplay between seat and venue was reiterated in BGS Soma, where the Supreme Court has held that in cases where parties has not defined the seat, the venue agreed upon could be construed as the seat. It must be mentioned, however, that the concept of seat assumes significance where the parties have consented to a seat in country which is different from the country where an application law is related. Then para 25, the principles enunciated in the decision cited can be structured thus: an application under section 9 can be filed where the part cause of action has arisen, or where the seat has been chosen by the parties, with the definitive caveat that the court determined otherwise has the jurisdiction to receive and adjudicate the disputes between the parties. As discussed above, the petitioner has stated that part cause of action as pleaded in paragraph such and such has arisen within the jurisdiction. It must be also borne in mind that the parties have consented to the jurisdictional clause, clause 18K, as well as the seat of arbitration as in 18L. Both the clauses point to Kolkata. The objection is to the interpretation of the outer limits of city of Kolkata and whether the clause can be stretched to include greater city of Kolkata. Section 21E of the 1996 Act designates the principal civil court of original jurisdiction in a district, including High Court, in exercise of ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of the arbitration for the purpose of applications in matters of domestic arbitration under Part 1. The discussion would have been different had the issue in the present case been one where the petitioner would be left to rely only on the seat venue of arbitration without assistance of the exclusive jurisdiction clause pointing to Kolkata. Section 21E1 as well as the effect of Commercial Courts Act have fortunately come to the aid of the petitioner to anchor the proceedings to the High Court at Calcutta as the only available court to decide the matter. The presumption of the contract having signed at office of the petitioner situated within the origins of jurisdiction also tilts in favor of the petitioner. So it says that it defined it. Discuss the difference between the greater city of Kolkata and the Kolkata courts. Kolkata court says that Calcutta High Court will have jurisdiction. Because Your Lordship, original Kolkata has been considered as a district here. And Lordship, we have also pleaded in, even though it is not required, but para 40, we have pleaded that the agreement was executed within the jurisdiction of the City Civil Court at Calcutta. That is my pleading. And Lordship, this same issue has been decided that once it is said Kolkata will have jurisdiction, it means Calcutta High Court. Yes. This is another judgment, Your Lordship, this 2023 SCC online, Calcutta 3769. It also says Kolkata means Calcutta High Court. Is the principal civil code of the district. Your Lordship sees the arbitration clause which was involved here in clause 9, by para 9. This is the arbitration clause. Similar to our, Your Lordship will see para 9 after clause 16, this last line of second para in under clause 16. The venue of the arbitration shall be at Kolkata. In our case also, venue is at Kolkata. And all suits arising are subject to jurisdiction of courts in city of Kolkata and no other court. In our case also, city of Kolkata will have exclusive jurisdiction. And then Your Lordship will take para 11. Therefore, the exclusive jurisdiction of on the court in Kolkata as provided in the final arbitration agreement between the parties would have primacy over New Alipur court as provided in the earlier contract. First, as stated above, the clause 33 of the earlier contract, which aspires to be the arbitration clause, does not designate either the seat or venue of the arbitration. Para 13, the second clause at clause 16 provides for an arbitration to be conducted under the provisions of 1996 Act as amended and venue of arbitration to be in Kolkata. DVC award data says that the parties agreeing to the venue of arbitration to be in Kolkata would amount to designation of the seat also to be at Kolkata. The proposition put forward should be tested on the case law relied upon by both the parties. After these case laws have been cited, and Your Lordship, thereafter, my Lord will take till para 19. Case laws have been cited. Para 19, if I may be allowed to read, the respective high courts came to the conclusion that designated seat would confer exclusive jurisdiction on the courts at the seat and the venue would become the seat when the latter was not specified. The courts also made distinction between subject matter of arbitration and subject matter of the suit for the purpose of identifying the court. Then para 21. The first is on the issue whether designation of a place, venue or city in the city of Kolkata would be construed as the seat in the arbitration agreement. The arbitration contract does not designate the seat. However, relying on the law pronounced by Supreme Court in BGS Soma, the city in Kolkata would also be read as jurisdictional seat. In other words, the court at the city of Kolkata would have exclusive jurisdiction with regard to the subject matter of the arbitration. For further clarification, the expression city of Kolkata has been defined in section 2, subsection 3 of the City Civil Courts Act to mean the area comprised within the local limits of original jurisdiction of the High Court at Calcutta. Civil Courts Act আছে আনতে বলেছিলেন যে Madam, if I may cite section 3 which has been cited herein, what is the definition of Kolkata? আচ্ছা বের করে দেওনি প্রেসিডেন্সি স্মল প্রজেক্ট কোড এনেছে সিভিল কোড একটা কথা just citing para 22. Therefore, the Calcutta High Court would be the designated seat of the arbitration agreement, which consequently would confer jurisdiction to this court, determine and adjudicate all the disputes. So, courts in Kolkata, city of Kolkata is Calcutta High Court. Your Lordship, my learned friend might also submit that if city in Kolkata, there are two courts, City Civil Court and Calcutta High Court. But here, suppose in one district, if there are two courts, the superior court will prevail under 2-1. So High Court will have supremacy over the City Civil Court. Your Lordship, this issue was also decided. I will not cite the, I will just give the paragraph number. That when there are two principal civil courts in a district, superior court is the High Court, and section 9 will prevail in High Court, has to be filed in High Court. 2015-1 SCC 32. My lord, we'll just have a look at para 15 of the judgment.
Yes.
My lordship, this is the definition of what is Calcutta. So far the jurisdiction is concerned, means the area comprises within the local limits of the time being for the ordinary original civil jurisdiction of the High Court.
You're reading from?
Lordship, this is City Civil Code section 2. This is what has been referred in that judgment, so I'm just showing the provision. Lordship, there are two prayers. I'm only seeking that they should not restrain the owners of phase 2 who has paid a substantial sum of accessing the club. That's it, by putting a blockade.
Now, let's first and foremost, what my learned friend, but he placed everything, but unfortunately did not place his own application. And he takes the section 9 application one. What is this case? First of all, this 2(1)(e) point, courts have decided what it is. I'll show a Supreme Court judgment which it says makes this demarcation. With the suit for land, it's a different kettle of fish altogether. First and foremost, kindly takes his application. I thought he would place that. Kindly have a look at it.
He's relying upon suit for land. I have two judgments. There cannot be a suit for land.
Yes, I thought, he has concluded. Now he goes into something else.
No,
Let
if he
finish,
says it's a
if
suit for land. Anyways.
I did not interrupt him. But I would expect, my learned friend to also reciprocate the same.
Yes.
Well, let's kindly have a look at the cost title first. But it is his own case that both are outside the jurisdiction of this honorable court. The association as well as his clients. Both are outside. Now his case is with regard to entry and exit of that particular. He says that it has been blocked. First incorrect submission made by my learned friend was that is the only entrance to the club. Your lordship put a pointed query. The map which he has given, kindly takes the map first at page 223. Your lordship put that question to my learned friend. I thought he would be candid enough to say the correct thing. Now let's kindly see the entire boundary wall is there, and there is also an entrance to the club from the other side as well. It is not that this is the only entrance. And my lord, the actual case is he wants to give membership to outsiders who will come in every time from there. And I'll show it from his petition. That is his actual grievance, not phase 1 and phase 2.
Which is the other entry?
Your lordship sees this entire boundary, which he has only given, this map. This is entirely in the premises. This is not the only entrance. The only access point which has been marked. In fact, the agreement which he shows talks about access points. That also I will point out. But this map itself shows, there is other passageway also, if your lordship sees. This entire passageway is also there, which this is not the only entrance. Otherwise, my lord, the phase 2 people would not have been able to enter their own buildings, if I take his submission to be correct.
That's why I asked him.
But my lord, your lordship asked a pointed query. He said, my lord, this is the only entrance.
According to him, the phase 2 people can only enter their own phase 2 also through phase 1.
But that is according to him.
Phase 2 has no entry from any other side.
But that is incorrect.
That is outside road which is referring to. From that is only.
If I understand correctly your argument, then not only the club, but even the phase 2 people cannot enter their premises or property.
No. Property, there is no dispute. Club. Only the access to the club has been blocked.
Club is not separate from the phase 2. All right.
Separate from the phase 2. There is a common pathway from phase 2 to phase 2.
Please understand. club is part of the phase 2.
Phase
It
1.
is
Phase 1. That is my case. Pleading.
no. Phase 1 is blocking phase 2 where the club is.
No.
Where is the club?
My case is that if your lordship sees the pleadings, club is inside phase 1. Phase 2 was constructed later on by the same developer, adjacent to each other. Now there is a common pathway from phase 2 to phase 1 to access the club. That has been blocked. Otherwise, we would not have any difficulty. We would not have come to court.
But your map doesn't show that.
Yes, your lordship, that is what the map is. Lordship, that is
Which
also
one
my
is your
pleaded
phase
case.
1, which is your phase 2. Your map doesn't have that clarity. And that's why I asked you this.
No, lordship, phase 2 is this part. Phase 1 is this where the club is situated. This
Where
is
have you
only
mentioned
access.
all that, sir?
Sorry,
Where is mentioned in your map?
Map it is in wordings not mentioned, but I have pleaded that.
No, not wordings. At least where's the demarcation even in the map? Where's the demarcation in the map? That's why this club which you're showing at the top.
Yes.
It's part of what?
Phase 1.
Phase 1. So your right side is phase 1?
Correct.
When I asked you, you said left side is phase 1.
No, my lord. I have all along said that club is inside phase 1. This is the access road. This is block. This is phase 2. This side. On the lower side, it is phase 2. From phase 2, people access to phase 1. This is the only common pathway to phase 1 to access the club. Map may not have been in drawings. It may not have been very clear in the drawing. I have not been able to. But I have not been able to make my lord understand in drawing. It may not be very clear. But the lower side is.
I asked you clearly, sir. The view. See, that's the problem. When I ask a question, you don't give me the correct answer. I asked you here also, which one is, this is your phase 1?
Phase 1. Yes.
You said this is phase 1, by the way.
No, then I might be mistake, your lordship.
You have made a mistake.
I mean, making your lordship understand.
Is this part of, the club is part of phase 2? You said yes, the club is part of phase 2. And that's why.
I am very sorry, if your lordship, it's my mistake. I have not been able to make my lord understand.
Asked you very clearly. It was a pointed question.
No, my mistake, my mistake.
I was asking anything else.
Your lordship, my mistake. Your lordship, it is kindly see it. It's your lordship, will kindly have a look at this.
No, you mark it there. You mark it there in your, own page.
Demarcate kore daw. Are demarcate kore daw.
Just write on top phase 1, phase 2.
It is written here, lordship. It is written in the map. Lordship, kindly see it is written. Phase 1, phase 2. This map I had.
Which is this one?
Same map এখানে phase 2, phase 1.
Give us the copy.
Wait.
All right. So this is part of phase 1 itself, the club.
Yes, ma'am.
So now phase 2 people cannot access it.
Correct.
That's what you're saying,
That is
because
yes,
the phase 1 is blocking.
Yes.
Entirely different. Okay. Okay.
So now, Malaj, if this is his case, now Malaj kindly takes his paragraph 1. What is his case? That paragraph 1, he says, if your lordship takes page 2 and beginning, my lord, end of page 2 and beginning page 3, he says, the dispute particularly in relation to access and use of the club building known as the Club 360 and its related facilities, which is situated.
Where are you rating it?
Malad, the page 3.
Page 3, yes.
Malad, right at the top.
Yes.
The second sentence, particularly in relation to access, if your lordship has got it. 2. And use of the club building known as Club 360 and its related facilities, which is situated in the residential complex known as Loharkua Green Heights. And this is his case. Then your lordship directly kindly takes. That kindly comes to paragraph 16. This is the real intention. This is his own case. This is the fulcrum of the dispute. Page 11, paragraph 16. The petitioner states that apart from the flat owners, so apart from the flat owners, several other persons are also desirous of being members of Club 360 degrees. Is also situated in the Green Height complex. So, my lord, they want to give membership to outsiders. And that access, my lord, that is the actual dispute which has happened between the association and the builder. And it is with regard to entry and exit into this immovable property. So, my lord, his submission was that a dispute with regard to my lord, entry and exit into an immovable property is not a suit for land. My lord, my submission is that it is a suit for land, and it has been held so. And the implication of it being a suit for land would have an effect even on a forum selection clause. Now, your lordship kindly sees now what he says. My lord, again, paragraph 17, he reiterates that. Your petitioner states that apart from the flat owners residing within the residential complex known as Loharka Green Heights Phase 1, several other persons, now kindly note this, from the surrounding locality. So he wants to use the club facility, which he thinks is for the members of Phase 1 and Phase 2. He wants to now commercialize it by bringing in outsiders from the neighboring neighborhood. This is his case. Have expressed a desire, willingness to obtain membership, which is a recreational lifestyle facility conceived, developed, and operated by the petitioner. So, this also makes it a commercial dispute. I shall show the judgment on that. This also brings it within the purview of a commercial dispute because he is monetizing it, he is commercializing it, he is running a club premises from this particular society. Now, if your lordship then takes, again, the same thing is mentioned, my lord, at the end of paragraph 17. That's why, my lord, my learned friend placed everything, but did not place a single paragraph from his petition. As well as other persons outside the residential complex. So he wants to give, this was the real purpose. Now, in paragraph 18, he says, my lord, this is where he says that this is a particular facility solely owned by him for recreational activities. Then he says phase 1 and phase 2, but he is not keeping it restricted to phase 1 and phase 2. He wants to give it to rank outsiders. Now, after
that's
this, mentioned in the clause also. Yes, my lord. That's mentioned, but my lord, that agreement.
That's mentioned in the agreement that it can be used by other people.
Other people
So it
also,
is
but
not confined only to the
no, it's mentioned in the other agreement. My lord, that agreement somehow is not the subject matter of this arbitration. That my learned friend didn't point out. He has invoked a specific arbitration clause, which is in terms of a handing over agreement. My lord, I'll show that. He has shown agreements, but he has not shown who the parties to those agreements are. Now, if your lordship sees 24, the club 360-degree facility as such and such was developed as a flagship recreational amenity associate and forms an important component of the petitioner's brand, reputation, and commercial goodwill. So, here it brings in the commercial angle. Why this is also a commercial dispute. Now, let's kindly see 25. Same averments. Your petitioner states that the petitioner has already invested substantial financial resources towards the development, maintenance, and operational management of class 360-degree facility. Obstruction created by the respondent association has not only caused operational disruption, but also threatens to cause substantial financial losses to the petitioner. The main thing is to the losses to the petitioner. This fact that phase 2 is complained, this has all been set up subsequently. Now kindly see, the petitioner in as much as the club facility derives its revenue from membership fees. My lord, they are receiving all this. Now, my lords, paragraph 29, my lord, they say about ingress and egress to the club, which is the immovable property. Why it makes it a suit for land. Now, if your lordship says again 30, again he says the same thing, commercial part, commercial goodwill and contractual rights, para 30. And thereafter, if your lordship sees 31 is again he says obstructing access, ingress and egress. And then, my lords, takes 34, again they are saying that they want to give it to outsiders. And now, if your lordship says directly, He says we have a right to give it to whosoever we want, and we can give it to outsiders and other intending members. Now, more importantly, and 39 also ingress egress is there, and more importantly, para 40. So how he invokes jurisdiction is, he says that handover agreement dated 21st August specifically provides venue of arbitration Kolkata. Agreement further records that the Kolkata shall have exclusive jurisdiction. This is his only averment with regard to jurisdiction. Nothing else, nothing more. All the submissions from the bar, etc., not reflected in his petition. And law requires him to plead how and on what basis he is asking for, and brings in this jurisdiction. And more importantly, his entire arguments get defeated. Kindly sees 40. Moreover, the agreement was executed at City Civil Court at Calcutta. So he himself says, he makes the distinction. I am grateful to my learned friend for making this distinction. Now he says that this agreement was executed at City Civil Court at Calcutta. This is his case. Now, give me the telephone. Well, it's exactly an identical issue came up, my lord, before the Honorable Delhi High Court. First, it's a Trihant, no? I may hand over, my lord, a copy. Copy the other. Let's kindly have a look at this. My lord, I've given my learned friend also a copy. But kindly see the prayer is also set out in the very first paragraph itself. That where would the gate be? And it's a dispute with regard to ingress and egress. Your Lordship will find that also in paragraph 2.
Yes.
Now your Lordship sees, my lord, this entire thing is, my lord, I'll take your Lordships directly to the point. My lord, it in fact also takes paragraph 3, cause of action for the petitioner to approach this court arose when respondents started providing entry and exit for the different blocks of the project under collaboration agreement at Gurgaon Sona Road, which falls within the jurisdiction of court at Haryana. The relief which the petitioner has sought from this court that the respondent should be restrained from providing exit near such and such. In view of these facts, the petitioner was asked to address arguments on the issue of jurisdiction of this court. Now, my lord, lot of other judgments are quoted. Now, if your Lordship directly comes to, my lord, paragraph 7. I also consider, since the property is situated outside the territorial jurisdiction of Delhi, this court would have no jurisdiction. The party entered into the collaboration agreement for development of the immovable property. The disputes regarding development of the property, construction, entry, exit. I'm just relying on this part. Entry, exit are the disputes in respect of immovable property and the rights of the parties therein. Then clause 16D of the Code of Civil Procedure provides that for determination of any right or interest of immovable property, the suit has to be instituted in the court within the local limits of whose jurisdiction the immovable property is situated. Whether the petitioner should have a gate on the main Gurgaon Sohana road or on the side road as sought to be constructed by respondent is a dispute of rights of petitioners in respect of the property only. It is not a dispute qua a personal right against the respondent. then the proviso cannot be explained in a manner that for every relief under section 16 of the Code of Civil Procedure, personal obedience is pleaded. For example, in case of clause 16A of the Code of Civil Procedure, if the respondent is in possession, or he can be directed to hand over possession, and the immovable property can be recovered by the respondent being compelled by personal obedience of such a direction of the court. Then, my lord, this goes ultimately, my lord, because of this, my lord, kindly sees what has been held. 8. In my view, proviso would not be applicable in order to invoke the jurisdiction under 2(1)(e), read with section 9 of the Arbitration and Conciliation Act, so as to claim relief qua the property is situated in Gurgaon, Haryana, from the court in Delhi. Now, my lords, this, my lord, has been subsequently also, my lord, followed up. Exact identical fact situation like ours. Copy the other. Lords. This is my lord 2010 SCC online Delhi.
We carry on with the judgments after lunch.
Very well.
With regard to item number 39, my learned
Second.
Milord, I am here, Milord, item 39, Milord.
Which one?
39.
We'll see when it comes. Keep your junior here.
Great.
Only this one. उसको ले ले. I'll just take this one.
Supplementary list. Information on judgment dated item number 1 EC 64 of 2024. Tanmoy Das and another versus Very Reality Private Limited.
I appear on behalf of the judgment debtors.
Hey, listen. Non-commercial.
Yes.
They've to comply with the award, my lord. They've not challenged it. Last occasion, my lord had recorded, if my lord kindly has the order of 13 November 25, my lord had recorded that a payment schedule was handed over to my lord. This is that payment schedule. May I just hand up? Oh, yeah. My lord, that's already there on record. My lord. They've not complied with this.
My lord, as per the last account statement,
Send
which
them
I have,
for civil imprisonment for some time. Let
my
them
lord,
be.
they have made
2
payments
weeks.
on the last occasion. My
Not after
clients are
13
here. There are
November.
80,000 which are possibly
No,
due
no.
and payable according to their own appropriation statement, which is
We'll
before
hear
your
you
lordship.
after they spend a fortnight in the jail. Let them come back.
I leave it up to your lordship, but on the last occasion, when your lordship, I have surrendered my client before your lordship on the last occasion. Your
But
lordship,
they're not making the payment. Why they're not making the payment?
there were some issues with the proposed file advocate record. I do not want to go into that. I am here before
Not
your lordship.
concerned with the advocate on record. I'm concerned with them. You have undertaking दिया आपने कोर्ट को?
Sir, only 80,000 is will not pending, which will make the payment.
Not even a single penny should be pending.
Yes, within 2-3 days we'll have it done.
80,000 is not the only.
You should have come with the money.
Sir,
I'm telling you, I'll send you to imprisonment for 2 weeks. You
Sir,
come back,
will
then we'll take the rest of the money from you.
Will it won't happen next time. We'll make the payment within 2-3 days.
You give it in 24 hours.
Sir, not to 24, 48, please.
24.
Okay, sir. Okay, my lord.
I'll send them for 2 weeks.
No,
When
I
you
ag-
come
okay,
back, then I know how to recover the money from the rest of. The rest also I take.
I'm praying for your lordship's indulgence. My clients don't know better, your lordship. I will make them aware. Give them a week's time. They will
They
make
know
the entire-
everything.
They are not aware of what your lordship
They
is
have
saying.
become hardened.
I apologize on behalf of my clients. Your lordship, I give them 1 week's time. They will make the payments. If they fail to do so, your lordship will put them to
They'll go
terms.
inside for 2-3 times. They'll start making the payment.
I bow down to your lordship. There is nothing else I can pray for your lordship. I apologize on behalf of my
24
clients.
hours. Let them make the payment.
Kindly will give them.
And what about their affidavit of asset?
That is in a different matter that has been affirmed in June.
That has been filed.
Yes, it is not
But
been
it's
filed.
not been here.
No, not this matter. Not this matter.
Absolutely not.
Not
is
this
my
matter.
learned
Lordship
friend
is
to
asking on in a different matter which they have.
EC relating to this award, no affidavit of assets. This have been
Let them
repeated.
file the affidavit of
Yes,
asset.
my lord. Yes, my lord. That's been directed long
The
time back.
amount which is pending, your lordship, there was an amount of 13 lakhs was pending to the award holder, and a 9 lakh rupees amount was pending to the which was payable to the bank. My clients have paid a substantial
I'm
amount of
not
money.
concerned.
As your lordship directs. Your lordship directs, I will file the affidavit of assets.
Take down. Give them the oath and all.
Repeat after
They'll
me.
file their affidavit of asset also.
I solemnly affirm
I solemnly affirm
that whatever I depose
whatever I depose
by way of evidence
by way of evidence,
shall speak the truth.
I shall speak the truth.
No part of it shall be false.
No part of that will be false,
And I shall not
and I shall not
conceal anything.
conceal anything.
What is your name?
Uday Modi,
Spelling.
UDAY MODI.
Your father's name?
Rajkishore Modi,
Rajkishore Modi. Your age?
41,
41 years. Occupation?
real estate.
No.
Residential address?
1/1A, Upper Wood Street. Upper Wood Street.
Upper?
Wood.
Upper Wood Street.
Kolkata 17.
Are you giving an undertaking to appear before this court as and when required?
Yes.
Yes. Do you know the consequences of breach of such undertaking?
Yes.
Undertake to file an affidavit of your assets before this court.
Yes.
Second one also. दूसरे का भी ले लो.
Repeat after me. I solemnly affirm
I solemnly affirm
that whatever I depose
that whatever I depose
by way of
by
evidence,
way of evidence,
I shall speak the truth.
I shall speak the truth.
No part of it shall be false,
No part of it will be false,
and I shall not conceal anything.
and I shall not conceal anything.
What is your name?
Raj Kishore Modi.
Raj Kishore Modi. K-I-S-H-O-R.
O-R-E.
O-R-E. Modi, M-O-D-I. Father's name?
Late Jagannath Modi.
Late Jagannath Modi. Your age?
66.
66. Occupation?
Business.
Residential address?
1/1A Upper Wood Street, Calcutta 17. Same as.
Are you giving an undertaking to appear before this court as and when required?
Yes.
Do you know the consequences of breach of such undertaking?
Yes.
You undertake to file an affidavit of asset before this court?
Yes.
The award letter number 1 and 2, namely Raj Kishore Modi and Uday Modi, have surrendered before this court. These are the award letter number.
Malad, these are the directors of the or singular award data. These are directors of the company. Award data is a company.
The directors of the award letter company, Mr. Raj Kumar Modi and Mr. Uday Modi, have surrendered. Both have been administered. Warrant of arrest discharged. They undertake to file their affidavit of asset within 3 weeks. Within 3 weeks. They also undertake to be present before the court as and when summoned by this court. Both the directors ensure this court that the balance payment of 80,000.
No, Malad. No, Malad. Balance payment as per their own letter is 9.35 lakhs. It's even more. We'll hand up a chart. As per their own letter that was submitted on 13 November 25 before this honorable court. That's
How
there on
much?
record.
How much time will you take to make the payment?
Months for this, please.
You have been given undertaking. You're always giving undertaking. I'll send you to jail for 2 weeks. Then I'll bring you out. Then I'll take some money. Then again send you for 2 weeks. And I'll continue this with you.
My lord, as you direct, my lord.
At least abide by whatever undertaking you give to the court. You can't flout the undertakings. Every time you come here, you give a false undertaking.
This time,
You don't comply with any of the orders.
this time it won't happen, my lord.
Let them remain personally present. That's my only prayer, Malad. Malad will record whatever they're undertaking, but let them remain personally present on the returnable.
Assures this court that they shall make the payment in terms of the award within a period of 3 months.
Award of 2020.
Then at least make the payment within 3 months. Keep after for compliance, we'll keep it after 6 weeks. After 6 weeks. Let's see how much.
Malad, let them.
If they're
That's my
complying.
only prayer. Let them remain present. Malad, at least one officer should be present in court, Malad, or else it will never be complied with. Always this happens.
My clients will be here, Your Lordship.
Malad, will kindly record that.
If
Malad,
they went
make it an
100%
order
on
of
the
this
list last time.
For compliance, list after 6 weeks for compliance. The directors shall remain present on the next date.
Obliged.
You be here on the next date. We will see how much money you have paid.
Obliged.
Grateful.
Yes. Yes.
Should we continue, my lord, with this? Or, my
Yes,
lord,
yes, we'll
lordship
continue with this.
have,
There was only one Passover, I think.
Yes.
Yes, we'll just, yes.
Your Lordship, in item number 1, I was supposed to file the terms of settlement.
or withdraw.
Learned counsel for the petition seeks to withdraw, it's a section 11, right?
Section 11.
Seeks to withdraw the present petition in terms of the settlement arrived at between the parties. The agreement date, yeah, this is the date? This is the agreement, where's the agreement?
3rd June 26.
June 3rd, 2026, Your Lordship.
Page 5 of the.
The agreement is not here. This is the agreement, okay.
Yes.
Yes, Your
It's
Lordship.
3rd of June.
Terms of settlement is there.
Dated 3rd of June. Third of June 2026. Full stop. Learned counsel for the respondent.
Respondent was 426.
426.
326. I'm sorry. No, 326.
Does not dispute the said contention. He states that they have entered into the terms of settlement with the petitioner dated 3rd June 2026. In view of the said settlement arrived at between the parties, the petitioner does not wish to press the present petition. The petition is disposed of in terms of the settlement entered between the parties. Petition is dismissed.
Apply.
As withdrawn.
Your Lordship will take the make the terms of settlement a part.
Terms of settlement is taken on record.
But after this, my lord, I believe the execution matters are there. My lord, Mr. Mitro is here, my lord. He's just waiting for this. So, my lord, the next matter is his. My lord,
Lordship, in that matter, I'm praying for time to file my reply. I've been served with opposition on 11th June. So I'm just praying for time to file my reply within a week or I'm being led by Mr. Jishnu Chaudhary in the matter, Lordship.
The
53.
Not on time. Not taken on record.
So in that event, Lordship, anyways, I'm praying for 1 week's time next week because I'm being led by Mr. Chaudhary. He's on his legs before.
That's the different ground. That's a different ground.
So they are saying not to take it on record. We will not file any reply. Then
Application under Section 5 of Limitation Act. For that, how much petition speak for itself. I won't rely on any affidavit of anybody.
Respondent number 3 has served an affidavit in opposition
Therefore,
on 11th of June.
Respondent 3 has not filed affidavit on time, and he has not taken any court leave either. So that has not been taken on record. He need not file a reply there too.
What is the item number in the
53.
This is the first item.
Yes.
Section 5 application. First item.
Mr. Mitra, we won't be able to take it. We are hearing one matter.
We are ready to go on.
No, there's a matter which is going on.
Oh,
for lunch. So I'll continue with that.
And if
So, Lordship,
my largest
keeps
friend
it
wants
next
time
week.
to
Lordship,
next
I'm
we'll keep it
obliged.
next week.
I'm obliged. Huh? No. Yes.
the next week maybe.
Next week.
Next week. Oh, very good.
53.
Yeah. Well, you better do
Next
week. Next week.
Yes. Next week.
Continuing matter, item 23.
2010, Dingrat. This is Dingrat. Look, I was going to rely, my lord, on another, my lord, subsequent, my lord, Delhi High Court judgment. But may I just hand over? কি লিখেছো এটা? ও এটাতে লেখা আছে, এটা আপনি লিখেছিলেন? ও But sorry, I didn't understand whether they have written it or whether it's a marked copy. No, quoted copy. And it's here also, if your lordship sees, my lord. The facts, my lord, are very similar to ours. Here also it was, my lord, same, my lord, with regard to, my lord. But kindly comes, my lord, to paragraph 2, your lordship will get the brief facts, my lord. Deciding the petition are that the petitioners and the respondents had entered into a lease agreement in respect of a premises situated at Gurgaon. The lease agreement contained an arbitration clause which provided that the seat of arbitration shall be Delhi. The respondent filed a petition under section 9 of the arbitration with a prayer that the court should pass an injunction restraining the petitioners and their agent servants from disturbing. Similar prayers are here also, I'll show. Disturbing peaceful use and enjoyment of the property in question, that is 830 square feet of area situated on the second floor of Mall cum Entertainment Center of the building at MG Road, Gurgaon. The other prayer was that the petitioners and their agents should be restrained from dispossessing the respondents and from dislocating and withholding any of the maintenance services, including electricity and water, to the demised premises. Then, my lords, paragraph 3, submitted by the counsel for the petitioners that the order of the trial court entertaining the application of the petitioner under section 9 was contrary to the established law and without jurisdiction. Then, my lord, section 16 was mentioned, my lord, in the very same paragraph. Then, my lord, paragraph 5, your lordship will see 2(1)(e) is quoted. Then, my lords, it is apparent that the question which the court has to ask is that if on the same facts a suit had been filed, would the court have jurisdiction to entertain the suit? This is the test. Now, my lords, kindly sees, in the present case, the property in respect of which the relief is claimed by the respondents is situated outside Delhi. The reliefs aimed are regarding dispossession from the property, not disturbing the peaceful possession of the respondents. Thus, all reliefs are in respect of the property. The plea taken by the respondents that the case was covered under exception is not tenable. The court had occasion to deal with such a plea in Trehan Promoters and Builders Private Limited versus Weldon Technology Parks Development. My lord, then Trehan is quoted. My lord, that is the one which I have cited already. Then, my lord, kindly now sees, my lord, directly now, my lord, paragraph 8. Merely because the seat of arbitration was provided as Delhi, or the agreement between the parties was executed in Delhi. My lord, pausing here for a moment. In this case, my lord, this is his only averment. My lord, I'll show, my lord, how true or, my lord, incorrect whether that averment is, but my lord, kindly sees, would not give jurisdiction to the court at Delhi to entertain a petition under section 9 of the Arbitration and Conciliation Act 1996 unless and until the court entertaining application under section 9 was the court defined under section 2(1)(e). In the present case, if the suit had been filed by the petitioner for claiming the reliefs in respect of the immovable property situated at Gurgaon, as claimed in the application under section 9, the suit would not have been entertainable in Delhi, as the suit was in respect of immovable property and not in respect of any act to done personally by any defendant. I therefore consider that the court below had no jurisdiction to entertain the petition under section 9, and the appropriate court having jurisdiction would be the court where the property is situated. The petition is allowed. Then, my lord, this was the order which was passed. My lord, these are the two Delhi. Now, my lord, the position, my lord, the test, my lord, nothing changes. What my learned friend says is, my lord, take it, my lord, he submitted that, my lord, that seat, my lord, is akin to a forum selection clause. My lord, taking that argument also, my lord, just, my lord, in an agreement, my lord, if there is a forum selection clause, my lord, a forum selection clause cannot confer jurisdiction on a court which otherwise does not have jurisdiction. That is, my lord, the principle of law. That, my lord, if in any event, my lord, a particular court,
according to you, which court will have the jurisdiction?
My lord, it has to be, my lord, before the Rajarat or Barasat, my lord.
But then what about the fact that this is the superior court in terms of the what he has relied upon a judgment?
My lord, that he says, my lord, with regard only to, my lord, that is confined to, my lord, I'll come to that judgment, that is only confined to, my lord, original site jurisdiction and all that. My lord, the highest principal court out there would be, my lord, the Barasat court. My lord, that's different. My lord, then in all event, if my learned friend's argument is to be taken into, my lord, no section 9 at all would lie, my lord, in, my lord, Barasat. Everything will happen out here by that logic. My lord, I'll come to the judgment which he has relied on. But more importantly, my lord, out here, my lord, even if your lordship sees the agreement, my lord, the parties are mentioned in the agreement. Your lordship has to decide basis that agreement. My lord, kindly takes page 169 of the application. 169 is in volume 2. Volume 2. Well, it kindly takes volume 2. So, my lord, kindly sees how this reads. This agreement made at Kolkata. My lord, it doesn't say agreement entered into at City Civil Court at Calcutta. My lord, that is also a misstatement, my lord, in his application. Kindly sees this. The agreement made at Kolkata 21st August. My lord, kindly sees between the parties. My lord, where the parties are also is at Kolkata, but not within the jurisdiction of this honorable court. My lord, kindly sees, my lord, where the developer is and where the, my lord, association is. Admittedly, both are outside the jurisdiction. And my lord, so is his cost title saying so. And that is why, my lord, he's made this entire argument that irrespective of the fact that anything is there, just because, my lord, it is mentioned in the agreement, Kolkata, therefore Kolkata. My lord, otherwise, my lord, he would not have been required to cite those judgments. Because he has, my lord, made his case that a neutral venue also can be chosen by parties to confer jurisdiction. My lord, only difference is, my lord, that a suit for land is a completely different thing altogether. My lord, suit, immovable property involved. It could not have been instituted anywhere else. My lord, now, my lord, I'll show, my lord, a recent Supreme Court judgment. My lord, lays down the same principle, my lord. But kindly takes this, my lord. But I've tried to look in SCC, my lord. Somehow it's not come, though, my lord, it says it's reportable. Copy the other one. Yes. And it's similar, my lord, again, the dispute between the welfare association and development, my lord, same, similar like us, my lord, same party, similar kind of parties, my lord. Kindly see, my lord, the fact, my lord, paragraph 3 onwards. The appellant filed a suit in the court of the Civil Judge Junior Division Karnal, seeking declaration, rendition of accounts, mandatory and permanent injunction with respect to the community center of Alpha International City, Sector 2829-8 Karnal, situated within a residential area, seeking declaration that the community center cannot be leased out to a third party for commercial purpose by the defendants with other ancillary reliefs before the trial court. The defendants moved an application under Order 7, Rule 11 of the Code of Civil Procedure, inter alia, raising an objection that in terms of Clause 23 of the agreement, dated 24th February 2009, the courts at New Delhi alone. So, my lord, same forum selection clause is here. He says seat is akin to forum selection clause. I am showing that there is a forum selection clause here also. And my lord, this is the very objection which was taken. Shall have jurisdiction in the matter arising out of touching or concerning the agreements, regardless of the place of execution. On filing reply, the appellant, the application was rejected by the court, wide order dated 31st January. The defendant preferred civil division number such and such, which was allowed in part, wide order dated. The High Court remitted the matter to trial court for deciding application afresh. Then, if your lordship kindly sees, learned trial court considered the submissions afresh, again rejected application wide order dated 19th April 2017, inter alia, on the pretext that territorial jurisdiction of the court cannot be ousted in lieu of the clause in agreement, in particular when the subject matter is the immovable property situated in Karnal and the cause to sue arose there. This is very important. Cause to sue arose there. In this conspectus, if your lordship takes our facts into consideration, everything is happening in Rajarhat. Nothing is happening out here. His averments have been that, his submissions also have been that obstruction, ingress, egress, boundary wall is being created, etc. And he has shown, a plan. My instructions are that there was a wall which they've broken down now. Actually, there was a wall outside, which they have broken down subsequently. Let them also produce, the architect's plan, the original building plan which is there. Because what they've done is now they've prepared a subsequent plan showing something else. Now, my lords, kindly see thereafter in this case what happens. Being dissatisfied, the defendants preferred civil revision bearing number such and such, which was decided by the common impugned order dated 27th November 2000, allowing the application and directed to reject the plaint, setting aside the order of trial court. The present appeal is against the said judgment preferred by the plaintiff's appellant. Now, if your lordship sees, again 16D is quoted, my lord, in paragraph 7 of the Supreme Court judgment. Now, my lords, all the suit for land judgments are taken into consideration. Harshad Chimanlal Modi, DLF Universal. Then, my lord, Swastik Gases, which my learned friend had cited a judgment, which I also referred to, my lord. Those were with regard to forum selection clause. Kindly see what it is said. It is argued that the impugned judgment court relied upon the case of Swastik Gases Private Limited versus Indian Oil Corporation Limited. But the said case does not deal with the case of an immovable property and is based on an agreement regarding business transaction. Well, in business transaction, a part of cause of action also would come into play. Well, that's a separate jurisdiction altogether. And well, that is why the difference is there with regard to section 16 and section 20 of the Code of Civil Procedure. Then, if your lordship thereafter sees, well, kindly sees thereafter, it is urged that where the court does not have jurisdiction to deal with the subject matter by virtue of a clause in an agreement, conferment of the jurisdiction to such court in a suit related to immovable property is not permissible. Then, my lord, this was the other side's argument, is, my lord, noted in paragraph 8. Now, my lord, paragraph 9 onwards, if your lordship sees. This is the, my lord, ratio of the Supreme Court judgment. Having heard the learned counsel for the parties and on perusal of the record, in particular the averments of the plaint, by which it is apparent that the present suit relates to the immovable property situated in sector 28-29 Karnal in the state of Haryana. The appellants have filed a suit seeking declaration, rendition of accounts, mandatory and permanent injunction in the nature. But in our case also, prayer B is with regard to a mandatory injunction which they have sought. Now, if your lordship sees, in the nature that no third-party right for commercial purpose can be given by the respondents in a property which is meant for the use of residents of the township. The respondents, on the basis of clause 23 of the agreement, claimed jurisdiction of the courts at New Delhi alone. But in our case, my learned friend is relying on the jurisdiction clause to say Kolkata alone, saying that this court has jurisdiction. Now, let's kindly see the said clause is set out. The clause is also set out here with regard to jurisdiction. Then, my lord, kindly sees paragraph 10. The said issue of jurisdiction is contested in terms of the provisions of the Code of Civil Procedure. Then part 1 of the Code of Civil deals with suits in general, by which it is clear that a suit in which right to property is involved is a suit of civil nature, and the civil court shall have jurisdiction to take cognizance of it unless barred expressly or impliedly. Then, my lord, section 15 is quoted. Then, if your lordship directly comes to, my lord, section 16, which is mentioned right after that, that subject to the pecuniary jurisdiction or other limitations prescribed by any law, suits for determination of any other right to or interest in immovable property shall be instituted in the court within the local limits of whose jurisdiction the property is situated. Further, section 17 makes it clear that where the suit is to obtain relief in respect of immovable property situated within jurisdiction of different courts, in that event, the suit may be instituted in any court within the local limits of whose jurisdiction any portion of the property is situated. My lord, this is very important. My lord, this relates to, my lord, the judgment which is cited in Indus. Because, my lord, Indus, several causes of actions were there, properties were at different locations, one particular property was there, and hence the court said, my lord, deholds, my lord, the fact that no cause of action has arisen, parties cannot confer jurisdiction, my lord, in my respectful submission, to a court, my lord, which otherwise does not have jurisdiction. And my lord, the position remains still the same. Now, my lord, if your lordship sees thereafter, therefore it is clear that in a suit related to immovable property, jurisdiction of the court would be at the place where the property or part thereof is situated. Otherwise, in other cases, as per section 20 of the Code of Civil Procedure, suit may be instituted where the defendant resides or cause of action arose, subject to the provisions of sections 15 to 19. So, my lord, immovable property, separate jurisdiction. For all other cases which do not involve, that will be, my lord, where defendant resides or where a part of cause of action has arisen. Now, my lords, kindly see the similar issue of interpretation of jurisdiction of courts in terms of section 60 of the Code of Civil was brought for consideration in the judgment of Harshad Chimanlal Modi while interpreting the issue of competence and jurisdiction of civil court. And then it is quoted, my lord, where it was, my lord, this whatever I'm urging, my lord, that is, my lord, been held. Now, my lord, kindly see 11. Reverting to the arguments of respondents, relying upon the judgment of swastik gases, the issues involved therein did not involve any immovable property. My lord, he has cited, my lord, my learned friend has cited altogether 8 judgments. My lord, I shall show, my lord, out of which, my lord, most of them, my lord, are not with regard to immovable properties. Now, my lord, kindly sees, they entered into an agreement for selling, marketing lubricants. As per clause 18 thereof, the agreement was to be subject to jurisdictions at Kolkata. The dispute arose between when large quantity of lubricant could not be sold. Accordingly, an application under section 11 was moved before Rajasthan High Court, which was objected for lack of jurisdiction. The matter related to the court, which is in appeal observed before us, my lord, then the ratio is set, my lord. Now, my lord, coming to, my lord, paragraph 12, which deals with the facts. Now, coming to the facts of the present case, undisputably, the suit has been filed before the civil judge, Karnal, seeking declaration, rendition, mandatory and permanent injunction with respect to the community center of Alpha International City, Sector 2829, Karnal. The said property is situated in Karnal. Therefore, the courts and Karnal, in whose local limits the property is situated, would have jurisdiction. Clause 23 of the agreement, executed and signed by the parties and by their consent, the jurisdiction is conferred on the courts at New Delhi. However, this clause would not override the jurisdiction conferred statutorily to the courts who may try and pass an order with respect to the property in question. Now, kindly see, my lord, it may not be out of place to put an example that in case of an agreement has been entered into between parties, not with respect to immovable property, if it's not with respect to immovable property, but for business transactions or otherwise, in that situation, where the immovable property is not involved, subject to the limitations prescribed under law, by virtue of an agreement, the parties may decide regarding place of sue and conferment of jurisdiction to the court. It may be one of the places where a part of cause of action arose. Again, with caveat that the parties by agreement cannot confer jurisdiction on a court which otherwise it does not have. But in case of immovable property, by virtue of the agreement, the jurisdiction cannot be taken away from the place where the property or part thereof is situated as specified in section 16 and 17. In other words, it is not open to the parties to confer jurisdiction on a civil court by agreement which it did not possess under the Code of Civil Procedure. My learned friend is exactly trying to do that by saying that just because parties have said, my lord, this would, my lord, kindly imagine the situation, then for all matters, my lord, parties sitting in Kolkata can, my lord, have an order with regard to a property, my lord, in Jammu and Kashmir. By if my learned friend's argument is to be taken to be correct, my lord, this would, my lord, this is not the intention of the act or the statute or the legislature. My lord, even from his cases, my lord, something has to happen within the jurisdiction of this court to confer jurisdiction of this court. My lord, that is not his case. At least that is not his pleaded case also. My lord, his pleadings, my lord, I have placed in details, my lord. He has nowhere said so. And that is why, my lord, I relied on these judgments. Then, my lord, kindly see, in view of the discussion made herein above, The High Court committed error in allowing the application and rejected the plaint by the impugned judgment. As such, we set aside the same and reject the application, holding that the suit is maintainable at Civil Court Karnal and it be decided on its own merits. But here the situation is reversed, my lord. He is, my lord, coming and saying, my lord, it should happen here. I am saying because the property is situated out there in Rajarhat, my lord, Barasat and, my lord, or the commercial court at Rajarhat. My lord, in this case, because, my lord, it's a commercial suit, according to me, it should go before the commercial court at Rajarhat. Let's now, my lords, I am relying on a Supreme Court, Honorable Supreme Court judgment, my lord, reported in 1971, Volume 1, SCC 286, my lord. Kindly have a look at this. My lord, kindly takes paragraph 4, my lord. The Court of Civil Procedure in its entirety applies to proceedings under the Arbitration Act. The jurisdiction of the courts under the Arbitration Act to entertain a proceeding for filing an award is accordingly governed by the provisions of Code of Civil Procedure. By clause 13 of the agreement, it was expressly stipulated between the parties that the contract shall be deemed to have been entered into by the parties concerned in the city of Bombay. In any event, the respondents have their principal office in Bombay and they were liable in respect of a cause of action arising under the terms of the tender to be sued in the courts at Bombay. It is not open. I'm relying on this portion. It is not open to the parties by agreement to confer by their agreement jurisdiction on a court which it does not possess under the code. But where two courts or more have under the Code of Civil Procedure jurisdiction to try or suit, an agreement between the parties that the dispute between them shall be tried in one of such courts is not contrary to public policy. But my lord, dehors everything. My lord, I can't say, my lord, that the suit can be instituted here. Unless, my lord, there is something to show that something has arisen here. My lord, that is not the case. Now, my lord, this, my lord, and this principle, my lord, your lordship, the one which I relied on, my lord, the unreported judgment, also says the same thing with regard to, my lord, immovable property. You can't confer jurisdiction on a court which otherwise does not have jurisdiction. No, give me excellent. Suit for land. Look, this was a judgment, my lord. This actually went from Calcutta High Court, my lord, with regard to, my lord, suit for land. And, my lord, it was held, my lord, considering all the judgments, my lord, because it involved, my lord, here also, though, there was a, my lord, forum selection clause, my lord, still, my lord, the court said, my lord, that because it's a suit for land, my lord, it has to be instituted, my lord, at the place where the jurisdiction is. My lord, may I just hand over a copy of this, my lord? Suit for specific performance or sale of land situated in Mumbai was filed in Calcutta on its original site, clause 12 of letters patent. My lord, here, my lord, kindly sees, my lord. The immovable property, my lord, your lordship will find is mentioned in paragraph 4. And, my lord, here, in this case, my lord, the unique part is, my lord, there is only one property, and, my lord, which is all in Rajarhat. That kindly sees paragraph 5, an application first filed saying that this was effectively a suit for land and the immovable property was situated in New Mumbai, Maharashtra. Therefore, as per clause 12 of the letters patent, the suit should have been filed in a court having territorial jurisdiction over the immovable property. Then, if your lordship directly takes paragraph 10, my lord, a heading is given suit for land. Then, my lord, clause 12 of the letters patent is mentioned, and my lord kindly sees paragraph 13. A suit for land is a suit in which the relief claim relates to the title or delivery of possession of land or immovable property. If by averments in the plaint and prayers therein it appears that the suit is one for land, my lord, very important, the averments in the plaint and prayers therein. It appears that the suit is one for land, it shall be so held, and if it does not, then, my lord, the suit shall continue before this Honorable High Court. Then, my lord, ultimately, my lord, Atcons is also quoted out here. Then, my lord, the sales certificate is mentioned. Ultimately, my lord, it was held, my lord, that the suit is not maintainable before Calcutta High Court. My lord, that is paragraph 16. My lord, forum selection clause was also dealt with. The paragraph 16 says it was a suit for land. And, my lord, paragraph 20, in view of the above mentioned two findings that the present suit is a suit for land, the parties had granted jurisdiction to the courts of Mumbai. The jurisdiction of the court at Calcutta is clearly ousted as per law. Thus, from the above conclusion, it appears that the plaint will have to be returned by the Calcutta High Court as it does not have jurisdiction. My lord, suit for land was one part, jurisdiction clause was another part. On both counts, my lord, in this case it was held. But, my lord, my emphasis is on suit for land. Now, my lords, more importantly, now, my lords, kindly see what my learned friend, my lord, has relied on, my lord. Lord, he has relied on around 8 judgments, my lord. Give me first the Delhi High Court, which he says has been followed, which is 2023 or Moonwork. This is a purchase order. No, my lord, the judgment which they rely on, my lord, is 2025 SCC online. Lord, 2797. My lord, first of all, my lord, this wasn't an application, my lord, if your lordship sees under section 9. It was an application under section 11.6.
2025 SEC 3069.
No, my lord, it's 2797.
2797.
2025 SCC online Delhi 2797.
Moonwalk.
Yes, my lord, Moonwalk.
You still try to do the moonwalk, or you want to withdraw and go before Rajarat?
Follow these.
Lordship is referring this.
See, the immovable property, it pertains to immovable property. It's very clear, the law, wherever the property is, you have to go there. Your agreement, your clauses in the agreement will not really influence it.
Lordship, that if my learned finishes, I will satisfy your lordship. Why this cannot be a suit for land. Suit for land only happens when I am seeking for delivery, if I am asking the court to decide the title. Here it is only a breach of agreement. And all these judgments are cited in respect of a suit and prior judgments of Indas. Indas has interpreted the law in arbitration that even if there is the jurisdiction cause of action has happened somewhere in section 16 does not apply in arbitration. Indas judgment.
Let him finish.
Lordship will hear me today or in
Hear
reply?
you today, yes. Depends on, today we have a 3:30.
3:30.
I don't know how much time will it take.
Well, I have to deal with 8 judgments he cited without giving me copies. I have to
Obviously
get
not
copies.
today.
And, my lord,
No, no, your lordship can keep it to some other day. I have no difficulty. Because any this is heard on ad interim stage, your lordship, this matter is being adjourned, lordship can hear it on any other. I have no difficulty if your lordship hears it on any other.
Yes, we'll hear it.
if your lordship takes this judgment, my lord, which my learned friend has relied on, 2025 SCC Online Delhi 2797. My lord, first kindly sees this is a petition filed under section 11(6) of the seeking appointment of an arbitrator for adjudication of disputes. The said purchase order, my lord, very important, kindly sees what is the dispute arising out of. It's a purchase order.
Yes.
The said purchase order is governed by the governing law mentioned in the techno-commercial order. The facts are the respondent approached the petitioner to supply and build a plug-and-play pre-engineered multi-story building in the industrial area of Begusarai, Bihar. On 21st January 23, the petitioner submitted its techno-commercial offer for phase 1-4 in accordance with the building's layout, overall dimensions and designs load of the project. The said commercial offer contains an arbitration clause. Then the clause is quoted, my lord, saying it will be Delhi, India. Pursuantly, the respondents issued purchase orders to the petitioner. At the top of purchase orders, it is mentioned all subject to Begusarai jurisdiction. So, my lord, the techno-commercial document had one clause, and my lord, the purchase order, my lord, finally which was issued has one clause, my lord, which says Begusarai jurisdiction. My lord, there was also, my lord, governing law and, my lord, a jurisdiction clause. Then, if your lordship sees, since there were disputes, my lord, termination of contract. Very important, my lord, it relates to a termination of contract. Then, my lord, to that effect, my lord, kindly sees. Then the submissions continue, my lord. Courts have time and again held that in the absence of a specified seat of arbitration, then it goes to venue designated for arbitration proceedings shall be considered as a seat. In this regard, reliance is placed on the judgment, again BGS Soma, my lord, is quoted. In the present case, arbitration clause contained in the techno-commercial offer, my lord, kindly sees explicitly stipulates that the venue of arbitration shall be Delhi. Hence, the seat of arbitration will also be Delhi. On the other hand, purchase order, well, very important, it's a purchase order, merely states in general terms that all subject to Begusarai jurisdiction. So, my lord, there was already a clause conferring jurisdiction on the court where, my lord, so this, my lord, judgment in my respectful submission has no manner of application, my lord, to the instant case. My lord, facts are completely different. Then, my lord, Ravi Ranjan is quoted, my lord, kindly sees, my lord, operative portion of Ravi Ranjan. This is also an interesting matter, my lord. Ravi Ranjan kindly sees the operative portion reads as under in Ravi Ranjan. Specified that the sitting of the arbitral tribunal shall be in Kolkata. In the said decision, the respondent himself approached the district court as Muzaffarnagar and not at Kolkata for interim protection under 9. The Supreme Court held that the respondent having himself invoked the jurisdiction of the district court at Muzaffarpur is stopped from contending that the parties had agreed to confer exclusive jurisdiction to the Calcutta High Court to the exclusion of other courts. It was further held that neither of the parties to the agreement construed the arbitration clause to designate Kolkata as a seat of arbitration. Therefore, petition under section 11 was held to be not attainable. My lord, in Ravi Ranjan in Supreme Court, my lord, actually, my lord, held that because, my lord, this point was also there, my lord, because there was a property involved in Muzaffarnagar, it was held Calcutta High Court has no jurisdiction in this Ravi Ranjan itself. Then, my lord, kindly sees, I am in agreement with the observation made by the coordinate bench in Reliance and I am bound by the law and hence it is the court which will have jurisdiction to entertain trial petition in view of the venue of arbitration being Delhi. For the said reason, the petition is allowed, my lord, then arbitrator is appointed. My lord, this, my lord, is a case which would come under section 20, which is, my lord, not with regard to immovable property. Purchase order placed, my lord, with regard to, my lord, work to be done.
But why are you saying it's regard to the immovable property? I mean, what they are seeking is basically access. They are not saying that the property belongs to them or they are seeking any kind of right in the land. All they are saying is that the access should be given to them.
Well, that giving that access itself, my lord.
Will it lead to immovable property?
Yes, my lord. That
How?
I have shown, my lord, 2 judgments to your lordships on
Suppose
that.
there's a club here. Whatever club is here, there's one club here. Suppose we need access to it. Will it mean that I am even asking for the right title interest in the club?
My lord, that's how, my lord, with the deepest of respect, my lord, there are several judgments on suit for land. My lord, I'll show all of that to your lordship, that this has been interpreted in that manner. That when you're seeking an injunction, a particular right over that particular immovable property, whether it's for entry, exit, anything, my lord, that would involve, my lord, a right claiming in respect of an immovable property. My lord, they are asking for access, my lord, where the land is situated. My lord, very important is where it is situated. My lord, in this case, it's an immovable property. My lord, if somebody is prohibited from entering, my lord, forget about, my lord, if we, for a minute, my lord, digress, my lord, and we take an example, my lord, if somebody is prohibited from entering his house, my lord, at, say, my lord, Salt Lake, my lord, can he file a suit today in Calcutta High Court, if I may put it in question form? That is with regard to his entry and, my lord, exit. It has to be where the property is situated, where the immovable property is situated. And my lord, we have our high courts, my lord, we have several high courts on what is a suit for land. And my lord,
one of the judgments you have shown where the clause is similar.
yes, my lord, both the Delhi High Court judgments.
Exit is.
So, that is covered. Exactly, entry, exit is mentioned categorically, my lord. But may I just take your lordships back to that, my lord, how similar it is?
I didn't want to break your momentum.
Now, my lord, give me Indus first. Now, let's this Indus Mobile Distribution Private Limited, my lord, which they relied on, my lord, which, my lord, by which they said, my lord, that seat is, my lord, akin to a forum selection clause. My lord, kindly sees this 2017, volume 7 SCC 678.
Yes.
Lord, if I take his, my lord, my learned friend's argument to be correct, that seat is akin to a forum selection clause, my lord, the next pertinent question which would come up is, my lord, can a party or can parties, by virtue of a forum selection clause, confer jurisdiction in a court which otherwise does not have jurisdiction? Now, my lord, kindly sees, my lord, here, my lord, that issue was in fact answered, my lord, to an extent, which obviously my learned friend, my lord, did not place that portion. My lord, my learned friend has placed, my lord, up to, my lord, I think 19, if I'm not mistaken. Now, my lords, what is more important is, kindly see para 20 of that. When the jurisdiction, my lord, is between 2 or more courts, my lord, then parties can have a choice, my lord, that no, we don't want to go in court A, we will go to court B. My lord, that would be a forum selection clause. My lord, kindly see para 20. It is well settled that where more than one court has jurisdiction, very, very important, it has to have jurisdiction. My learned friend has not been able to demonstrate how this court has jurisdiction apart from the forum selection clause. It is open to the parties to exclude all other courts. For an exhaustive analysis of the case, see Swastik guesses, then this, having regard to it, is clear that the Mumbai courts alone have jurisdiction to the exclusion of all other courts, as the juridical seat of arbitration is at Mumbai. This being the case, the impugned judgment is set aside. The injunction confirmed, but most importantly, my lord, out here the point is, my lord, the other court also has to have jurisdiction otherwise. In this case, my lord, all his submissions have been My residents, those residents, my lord, have written letters. Letters to whom? My lord, to him. He is not within the jurisdiction. There has been a, my lord, according to him, some kind of an embargo created from them from moving in and out. My lord, where? Everything in Rajarhat. What has happened in this jurisdiction, my lord? My learned friend has failed to say. My lord, his pleadings are, my lord, absent. My lord, jurisdiction is a thing which is required to be pleaded in law. My lord, his only pleading is, I have a forum selection clause. My lord, that alone, my lord, that has been, my lord, taken care of by the judgment, my lord, which have relied on of the Honorable Delhi High Court, which says, whatever you might say, you can't do it in this manner. My lord, forum selection clause, my lord, like what it says is paragraph 20, where more than one court has jurisdiction. So both the courts should have jurisdiction, then you can choose one. My lord, this entire argument of seat, my lord, being, my lord, equivalent to or akin to, my lord, forum selection clause completely goes. Because that place also has to have jurisdiction in the first case. And more importantly, now takes, my lord, my learned friend relied on 2020 SCC Online Calcutta 1790. My lord, pleading is there in that matter with regard to part cause of action having arisen within the jurisdiction. And that is what the court has taken note of. My lord, kindly straight away, my lord, kindly comes to paragraph 25. 25 place করেছিল দেখো 2020. Now let's kindly take paragraph 25 itself. The principle enunciated in these decisions cited as structured thus, that an application under section 9 can be filed. Kindly see, where a part of cause of action has arisen or where seat of arbitration has been chosen by the parties with the definitive caveat that the court determined otherwise has the jurisdiction. My lord, this is the proposition. Then kindly sees, my lord, otherwise has the jurisdiction to receive and adjudicate the dispute between the parties. As discussed above, the petitioner has stated that part of cause of action as pleaded in paragraphs 2, 3, 9 and 43 of the application has arisen within the jurisdiction of this court. Well, this is what it is. Now, my lords, very important, para 26, the last portion of para 26. My lord, from the last 10 lines, my lord, the court must therefore proceed on a conjoint reading of the averments, the documents, and the strength of rebuttal of the party who asserts that the petition must be taken elsewhere. The first principles of the burden of proof under the would also come into play, namely that whoever asserts the existence of certain facts to a legal right must prove those facts exist. In this case, since the respondent has asserted that the court does not have jurisdiction to entertain the application, must discharge that burden by adducing evidence which would dislodge. But I am showing from his own averments today that this is his own case.
See this.
Sorry.
Yes, sorry. Let him file his reply. This can't be decided without.
Sorry, my lord.
Let him file his reply. It can't be decided without exchange of affidavits.
I was seeking an ad interim measure in the sense that they should not disturb the access.
No, ad interim measure
for the flat owners.
Granting you
crosses jurisdictional
jurisdiction issue, I will be able to. Lordship, only the ad interim that it is not affecting their right. They are not the owners. They are only for the maintenance. It is for the phase 2 owners to access.
We'll see that.
They should not suffer any prejudice.
Till the time we don't cross over the jurisdiction aspect, we can't really get into
So jurisdiction aspect, once he finishes, I'm ready to argue.
No, let them file their reply.
Let them file. I have no objection. Well, Lordship, may I only suggest one thing?
No, I will not.
At our cost, let security guards be installed. Let the security guards give access.
Not right now.
He will keep a
Cross over the jurisdiction aspect. Then
jurisdiction. He has not finished, my lord. After he finishes, I will give reply.
No, let him file his reply. I want exchange of affidavits
the
before I decide it.
But your lordship will give them a very short period of time because your lordship the matter has to be decided.
Very well, my lord.
Otherwise,
Short period only.
Yes.
Not going to stretch it far.
No, he has only taken time, my lord. Matter got urgent. took the 2-1E.
I also understand your junior has also taken time twice. I have not objected.
Anyways,
Twice.
it's all recorded.
I have not
Very well, my
objected.
lord. Anyways,
I
I
have
don't
not
want to
objected
get
to
into
that.
this.
Why are we
So,
getting
please
into
don't make this prejudicial
the
submission. The
petitioner.
junior has also
Take on.
taken time on your. I have
The
not.
petitioner has preferred the present petition under section 9 of the Arbitration and Conciliation Act 1996. Seeking interim protection by way of an order restraining the respondent from blocking or obstructing the internal common ingress and ingress through the pathway connecting. What is this? Loharuka Green Heights and Loharuka Green Heights Phase 2, particularly in relation to access to Club 360. Learned counsel for the petitioner submits that the dispute had arisen between the parties in terms of the handover agreement dated 21/8/2025 executed between the petitioner being the developer and the respondent association of apartment owners. Full stop. Learned counsel for the respondent at the threshold states that the present petition is not maintainable and this court has no jurisdiction to entertain the present petition. Full stop. He states that the matter pertains to an immovable property and any direction given by this court will be concerning the right to the immovable property in the nature of a club 360 being the subject matter of the present dispute. Full stop. He further states that since the property is located outside the territorial jurisdiction of this court has no jurisdiction to entertain the present petition. Full stop. He seeks and is granted 2 weeks, 3 weeks.
The 3 weeks, my lord. He's filed also.
3 weeks
Kindly
time.
give them 2 weeks because I'm pressing for identity.
Do it in 2 weeks time.
Yes.
Very well, my lord.
2 weeks
Very well.
time to file
Very well.
his affidavit in opposition, reply to the same if any.
1 week.
1 week. List after 4 weeks.
Grateful.
Good.